Yeah, good morning. Tom Piotrowski on behalf of the plaintiff. It's not the way you wanted to start your day, I'm assuming.
It's always a pleasure seeing you.
This is for
I hope
Your Honor.
All right. Big Murray here.
I did not see her.
All right. She is not here. If you'd like to take a default, I see the second is paid for. Raise your right hand. Do you solemnly swear or affirm testimony you're about to give me the truth, whole truth, nothing but the truth, so help you?
I do, Your Honor. Thank you.
Go ahead.
All the documents, this is a case for possession only. All the documents have properly been prepared and served upon the defendant. Her not being here, she has not responded to the best of my knowledge. Everything has been properly handled.
Yes, in court's review of the file, everything is in order. Defendant having failed to appear, judgment to the plaintiff. That is by default for possession, no redemption amount, writ issue in 10 days. All right. Thank you,
Your Honor. Have a good weekend.
You do the same.
Thank you, sir.
120 Ypsilanti Group LLC versus Deja Cargill.
Thank you. Good morning, Your Honor. William McInnes, P80757, appearing on behalf of plaintiff.
Good morning. And Ms. Cargill, good morning.
Good morning.
All right, this is non-payment of rent case. What is the plaintiff's claim?
This is for possession only. Rent due and owing is $2,615 plus court costs of $168 for a total amount to retain possession of $2,783.
All right. Ms. Cargill, how are you intending on trying to get this paid?
Okay, I just started working like within April the 18th, and I told them I will make payment this Friday coming up. So I just received court papers within the last 2 days. So I was payment this Friday.
Are you going to be seeking assistance of any type?
Yeah.
Okay. So if you seek assistance, there's a form that came in your packet called a rental assistance form. You'll need to fill that out and get that to the court. You have to file that with the court by next Wednesday.
Okay.
Is there anything that you can pay between now and next Friday?
Now and next Friday, I can pay like $5.
Say that again. You keep turning away from your microphone.
I can pay $500. I have an earplug on.
Okay, you can pay $500. Can you pay that by the 21st?
Yes.
All right, pay $500 by the 21st. I would encourage you to contact plaintiff's counsel and see if something can be worked out prior to the next court date, okay?
Okay.
All right, so I will adjourn this to May 22nd, 2026 at 3 p.m. That's an in-person hearing, ma'am. Okay, so you have to come down to the courthouse, but see if you can call plaintiff's counsel and see if you can work something out, all right?
Okay.
Your Honor?
Yes.
So there is no Zoom option?
You can file the paperwork.
Okay.
Okay, but it is set as an in-person hearing.
Thank you.
All right, thank you. Arbor House versus Diane Beatito.
Good morning, Your Honor. Sidney Katz.
Good morning, Mr. Katz. Here. Where?
Hello.
Here he is. Hello, sir. What's your name?
My name is Gerald Vitito. I'm Diane's husband, and I should be also on the lease. But
got it. Okay. All right. What is plaintiff's claim in the case?
Your Honor, there's currently a balance of $1,791. That amount includes May rent and costs.
And costs?
Yeah.
Okay, give me that number again. I'm sorry, Mr. Katz.
1791.
Thank you. All right. Mr. Vito, how are you guys going to get that paid?
I'm prepared to pay May's rent by Monday.
Okay, so how much is that, sir?
I'll pay the $1,800 by Monday.
You'll pay the whole amount then by Monday?
Yes, sir.
Okay, so you're gonna pay the balance by Monday.
Correct.
Okay, so here's what I'm gonna do. I'm gonna adjourn this out to May 22nd, next Friday, 2026 at 3 PM. That's an in-person hearing. If you have everything paid off, I don't need to see you.
Okay.
Okay?
Okay.
All right. Thank you, sir.
I'm sorry.
Thank-
Could you get the attorney to repeat that number exactly for me, please?
1791, 1791.
Okay. Thank you so much.
All right. Thank you.
All right. Thank you.
All right. Mhm.
Thank you, Your
Bye-bye.
Honor. I'll see you this afternoon.
Yes, sir. Thank you. Court calls the case of Robin Mull versus Don Willard.
Hello? Hello?
Hello?
I'm right
I
here
just
for
wanted-
here.
I just wanted to
Morning,
make
Your
sure.
Honor.
you could hear me.
All right, sir.
I'm very good. Thank you, Mr. Lucas. All right. And Ms. Willard?
Yes.
All right, you're there. Okay, this is non-payment of rent case. What is plaintiff's claim?
Your Honor, there is approximately $7,840 owed with rent continuing to accrue at the rate of $980 a month. My client merely wants possession of this property.
All right. File this as
I
a
have a lease.
non-payment. I have this, hold on, man. I have this as a non-payment case. All right. So ma'am,
Yes.
the $7,840, Mr. Lucas, is that inclusive of the court cost?
No, Your Honor, the only quote cost is just a filing fee at this point.
All right. Ms. Willard, how are you intending on getting this paid?
I don't know. I have to move. I just signed a lease in another place. So, I don't know. Me and Rob were gonna work stuff out and, he wasn't gonna take me to court. He told me to keep the money and move, and that's what I'm doing. And I don't know why we're in court.
Okay, well, I can't answer that. It's here before
Your
me.
Honor?
I say this much, that they're claiming that you owe this amount. When were you planning on moving, ma'am?
I have my lease signed. I'm hoping to move by the weekend of the 25th. It's signed
Okay.
for the June 1st, but he's gonna let me in as soon as these people are out, and they're 90% out. So they
All
should
right.
be out by
So
next
here-
weekend.
All right, so here's what I'm gonna do. I can't get to next weekend, but I can adjourn it to May 22nd, next Friday, 2026 at 3 PM.
Okay.
Okay,
Your Honor?
and yes, sir.
If I may, I believe my client is willing to let her out without payment. And Mr. Mull, you can correct me if I'm wrong. You're on the call. If we could get a judgment today, a consent agreement.
I can't do that because of the way our statutes now read. She gets a week.
Okay, I just didn't know if she consented to it.
She's not represented by counsel, so I'm not gonna do that.
All right, understood.
So I'm gonna adjourn it out a week to the 22nd. If you guys want to work something out in between, then Miss Willard, you can call Mr. Lucas's office and see if you can work something out.
Okay.
All right?
My
Yes.
phone number, Ms. Willard, you have my
Yes.
phone number?
I'm not sure if I have your number. Is it on the papers?
It should be, yes, ma'am.
Yes.
Yes, it is.
Then I do have it.
All right. Give them a call, see if you guys can work it out. Okay? Thank you.
Thank
Your
you.
Honor.
Do I have to come in person next week?
Yes, it is in person, and yes, you have to come in person because you're unrepresented by counsel, certainly.
Thank you.
All right? Thank you.
Bye.
Beal Properties versus Teresa Idgens.
Good morning, Your Honor. John Capitan, P61901, appearing on behalf of Beal Properties.
I have Teresa and Terry Idgens.
Yeah, we're the same person.
I'm sorry?
We're the same person.
Okay. All right. Okay, and what is plaintiff's claim in this case?
Rent to retain is $691. cost of $220 for a total of $911 even.
All right. Okay. Ma'am, how are you going to get that paid?
I have an SCR filed. I'm working with Hawk and I'm hoping to get it up to speed. For the record, I have been paying, just not all of it, because I'm not making a livable wage right now. They're literally getting 95% of my money.
Okay, here's what I'm going to do. If you filed an SCR and you're working with Hawk, there's a form in your paperwork called the rental assistance form. You'll need to fill that out, file it with the court by Wednesday.
Okay.
Okay. We don't have a status on her. So.
That is correct. We do not. She's not.
Okay. Do you have an appointment with Hawk?
Not at this time, no.
All right. So I'll adjourn this to May 22nd, 2026 at 3 p.m., 2 p.m., excuse me. That's an in-person hearing.
If there's any way it could be 3 p.m., I actually work until 2.
I can't do 3 p.m. This one's slotted for the 2 p.m. block.
Okay.
Okay, so it's at 2 p.m. Make sure to file that paperwork.
And I'm sorry, what was the date?
The 22nd, next Friday.
Okay.
Okay, and always feel free. You can contact plaintiff's counsel's office, see if you guys can work something out before you get here.
Okay.
All right. Thank you. Beal Properties versus David Cole.
John Capitan appearing on behalf of Beal Properties.
David Cole. No response. If you'd like to take a default, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do, Your Honor.
Go ahead.
Upon information and belief and upon review of the records, the rent this is a possession-only judgment. The rent retained is $759, cost of $175, for a total of $934. We ask that the writ may issue after May 26th, and again, we're not asking for a money judgment.
Judgment to the plaintiff, that's by default for possession. Redemption amount is in the amount requested with the writ issue in 10 days. Is that it for you, counsel?
I have one more, Your Honor. Yes.
Oh, there it is. Yep, you sure do. Woodview Commons versus Whitney Albright.
And for the record, John Capitan appearing on behalf of Woodview Commons.
She said she's here.
Hi there. I'm sorry.
Hello. It's okay. All right. So Albright's here. What is plaintiff's claim?
Rent to retain is $2,926.13. Cost of $175 for a total of $3,101.13.
$1.13. All right. Ms. Albright, how are you intending on getting that paid?
I did fill an SCR yesterday, and then I was going to contact the lawyers just to see about a payment plan. I just was off a week of work, so I'm just trying to play catch up.
Gotcha. Okay. And how many people are in your house?
3.
3. Okay. So just so that you know, if they grant you the SCR, the maximum amount they're going to give you is about $600, a little over $600.
Okay. Yeah. I get paid next Wednesday. I get paid, and I can pay $1,200.
Okay, that was my next question. So you can pay $1,200 by next Wednesday, the 20th.
Yeah. Yes. So it comes in at the evening. So I would say Thursday morning, just to be safe.
Okay, I'll put the 21st. That's fine.
Yeah.
All right. Pay that by the 21st. Okay.
Yeah.
And then make sure that there's a form in your packet called a rental assistance form. Make sure to fill that out and make sure to put your SCR tracking number on that.
Got it. Okay.
Okay. And file that with the court by Wednesday.
Will do.
Pardon?
I said I can do that.
Okay. And then I'll adjourn this matter out to May 22nd, 2026 at 2 p.m. That's an in-person hearing, so you'll have to come down to the courthouse. You can always feel free to contact plaintiff's counsel, see if you guys can work something out beforehand,
Yes.
okay?
Yep. Thank you. I appreciate it.
All right,
That's it.
thank you. Great day.
That's it. That's it for me, Your Honor.
That's it
Have a
for
great
you.
week. Have a great weekend.
You do the same. And I do have, these are his, but yeah, Arbor Meadows versus Don Ho and Arbor Meadows versus Farik Hosen. Those matters are dismissed on plaintiff's motion without prejudice. Clark Road Family Limited Housing versus Cindy Ropchan.
May it please the Honorable Court, Steve Gann, P. 78209, appearing for the plaintiff.
Steve.
And Ashvin Jadadori. All right, they are both here?
Yes.
Okay.
Forward.
All right. This is a termination case. Scan, have you received defendant's answer?
I have not received an answer on this one, Your Honor. Has it been filed?
I have an answer in my file.
Yes, sir. And they have counsel present who hasn't.
Oh, he hasn't put his appearance on?
Yeah.
Oh, there he is. I got it. Counsel?
Good morning, Your Honor. Aaron Ogletree, about for the defendants.
All right. Have you served a copy of your answer on plaintiff?
Yeah, I was retained on Tuesday and I put it in the mail on Wednesday.
Okay.
I do have an email I can give you.
Okay. Yeah.
In fact, I'll pull up your email from the state bar so I don't waste the judge's time, and I'll give you my email address through there. I'll be in contact.
This is a termination case. Counsel's present. What I would do then, it looks like it's being disputed. You got to get your answer over to him. I would adjourn this out 1 week to the 22nd, 2026 at 2 p.m. That's an in-person proceeding. And then we can talk it through and see where we go from here.
Yes, with both attorneys, can we do that via Zoom?
If you file the paperwork, yes.
Thank you, Your Honor.
But otherwise, you guys will need to be here in person. Okay?
Thank you. And Mr. Ogletree, I'll reach out to you after the hearing here.
All right, thank you.
All right, thank you.
Bye-bye.
Bye-bye.
Thank you.
And then we have Group 5 versus Antonio Brown. Mr. Weiss, how are you, sir?
Good morning, Your Honor. Always a pleasure to see you.
Yes, and you, sir. I have a dismissal on your case. Is that what we're doing? Or?
Yes, I just didn't know if it got there in time. So yeah, we are dismissing it. All right.
All right. All right. Always good to see you, sir.
Always good to see you. And I'm sure it's always good to have me gone.
That's not true. But okay.
Have a nice weekend, Your Honor.
All right, you do the same. We have one person. All right. There's looks like, ma'am, can you unmute and tell me who you are?
Yes, my name is Venus Hurd, and I'm here because I've been late on my rent, but I've got to pay.
Hold on. Let's make sure who's your landlord?
My landlord is Soil Farms.
They're in the next block.
They are. Soil Farms is in the next block. Can you have her repeat her name again?
All right, ma'am. I think you're in the next block, but what's your name?
Venus Hurd.
Venus Hurd.
Look for JIS and see there.
You know.
I found her. Her case was dismissed last week and removed from today's.
Okay. All right, ma'am. Thank you for showing up. Your case was dismissed and got removed from our docket.
Okay. Thank you very much.
You're welcome.
Okay.
You have
a nice
great weekend.
Okay, you too. Bye-bye.
All right. I think that's it for that clock. All right. Thank you, folks. Court stands in recess. Did that one.
Hey, it said I was approved. And he's not around no more, so I took over it. And I just dropped off 1,100 in the mailbox for Northfield Estates. I'll have another 600 on the 20th and another 600 on the 26th.
Okay.
660.
Well, all right. Well, there's going to be some problems, but I got you. You're not an approved tenant.
They said I was approved.
And you get the dog shot.
I have to get my dog a shot, a rabies shot. That's all I need to do to get to be done. To sign the lease.
Your Honor, let's adjourn this for a week. Let me talk to my client and find out what's going on with this.
Okay. May 22nd, 2026. What time?
12 noon.
12 noon. Sir, that's an in-person hearing. Let me ask, since this is a non-payment, what is plaintiff's claim?
Right now, Your Honor, with cost $2,387.99.
All right. And sir, you indicated that you dropped off 1,100 already?
This morning at 9 o'clock.
Okay, so you dropped off 1,100 today, and then by next Friday, how much are you gonna pay by next?
On the 20th, I'll have 600, and then on the 26th, I'll have 660, whatever the remaining is.
All right. So the 20th, you're gonna have 600, and then we'll see you on the 22nd, and we'll figure it out from there. All right.
Thank you very much.
Thank you.
22nd at what time? 12. Okay.
12
thank you. Okay. Thank you very much.
You're welcome. Northville Crossing versus Clarence Carmichael and Barbara Carmichael. Clarence, Barbara Carmichaels, they're not here. If you'd like to take a default, raise your right hand. Do you solemnly swear or affirm? Testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God.
I do. Again, for the record, Rachel Dornbush, Valid Law, on behalf of the plaintiff. Your Honor, there's rent to retain of $1,863.42. Costs of $250 for a total due of $2,113.42. And we'd ask for a default possession only judgment with a writ to issue after 10 days.
Judgment to the plaintiff, that is by default for possession, redemption amount, any amount requested. Writ to issue in 10 days. James Ingram versus Jason Hopper. What? What did I say?
James versus James.
Okay, you're right. I said that, and I didn't mean that. Okay, you didn't have to call me out in public like that. No. Okay. All right, I'm gonna try it again. All right.
On YouTube and everything.
Yeah, I know. Now everybody saw that happen. Thanks, Ann. Northville Crossing versus James Ingram and Jason Hopper.
Gotcha.
And they're not here anyway. Really? Anyway, all right. Ms. Dornbush, you may proceed.
Thank you, Your Honor. There's rent to retain of $979.96. Cost of $250 for a total due of $1,229.96. And we'd ask for a default possession only judgment with a writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested with the writ to issue in 10 days. Let me see if I can get this one. Northville Crossing versus Michael Powers, Jessica Lindau, and Gary Lindau.
Here.
All right. There's Mr. All right. What is plaintiff's claim in this case?
With cost, Your Honor, $2,212.38.
All right. And sir, how are you guys intending on getting that paid?
I can have 500 on Monday, the 18th, and I can have another 1,000 the Friday, the 22nd, and I can have the remaining done the following week.
Okay, so you'll have 500 on the 18th, 1,000 on the 22nd.
Correct.
Can you get that paid early in the day on the 22nd?
I'm sure I'm going to see you, so yes, I will.
All right. Okay. So I'm going to adjourn this to May 22nd, 2026 at 12 noon. Okay, that's an in-person hearing. What I might suggest you do, sir, is in the interim, contact plaintiff's counsel's office, see if you can work out either a consent judgment or conditional order of dismissal. All right?
Sounds good.
Okay, thank you.
All right, thank you.
Have a good weekend. Court calls the case of Northville Crossing versus Rebecca White.
I'm here.
Hello, Miss White. How are
Hi.
you?
Good. How are you?
I'm good. Thank you for asking. I'll need a camera, please.
I'm trying. I'm sorry. I'm at work. I don't know how this works.
Oh, it's okay. While we're there she is.
See me?
Okay.
Okay.
Yeah, we see you. All right. Ms. Dornbush, what is plaintiff's claim?
With costs, Your Honor, $2,989 even.
So I actually just got this in the mail. I don't know if my son got the service or not before he moved out. So I didn't find out about this until last night. I do have some questions I would like to talk with my landlord about because I was in writ status in January. That was paid off. And then I made an additional $3,000 payment on February 20th. So I should not be this far behind. And I just need to get with her and go over my ledger because to my knowledge, I should only be 1 month at this point.
Yeah.
And that's this month.
Well, Your Honor, if she made a payment on February 20th.
Somewhere in that region. I don't have the ledger in front of me.
I've got the payment here on February 20th, but it's now May. So you'd owe March, April, and May.
That was for February and March that I paid in the end of February. So it should be April. And then, yes, now it is May.
Okay, so the payment that you made for $2,040.42 did give you a little bit of a credit going into March, but it wasn't enough to cover all of
So
March.
Bobby and I had a conversation. There was a large water bill due. My pipes exploded. And she was supposed, when I made the payment, everything went to the water, which they had agreed to a payment arrangement. She was supposed to finagle whatever with that, which is why I need to discuss with her what happens there. I mean,
So,
I
Ms.
have no,
White,
I know I'm behind and I do.
No, that's okay. Yep. Give me a call. Obviously talk to Bobby as well, but then give me a call. The paperwork that told you to appear today lists Matthew Pallets out of Troy. Give me a call at that number. And I'll also touch base with Bobby and see if we can.
Okay. Yeah, I just got back to work after fighting cancer last year and being out of work for over a year. So I'm really playing catch up at this point. It's just taking a little longer than I thought to pull out.
All right. All right. Here's what we'll do. I'll set this for May 22nd, 2026, 12 noon. That's an in-person hearing, but make the contacts that you're going to make and let's see where we are when we get back next week. Okay.
All right. Perfect. Thank you so much.
Thank you.
All right. Bye-bye.
Bye-bye. Whitaker Oaks versus Peyton Johnson. Johnson is. Peyton Johnson, we have at least some information on him. I'm not sure. Okay, we just have that there was a Friends Indeed referral made on May 7th. I'm not clear what that means entirely. But if you'd like to take a default, you may proceed.
Your Honor, I don't actually have an objection to adjourning it to next week if the court was inclined to do so based on that application. But I mean, I'll defer to the court on that. I mean, I don't know if the court's treating that
I'll adjourn
for tenancy.
I'll adjourn it now.
Okay.
May 22nd, 2026, 12 noon.
Thank you, Your Honor.
Thank you. Court does call the case of Scio Farms versus Eric Allen and Brittany Raymond and Mackenzie Earl. Do we have any of them? Allen, Ramon, Earl. No one is present. You may proceed.
Thank you, Your Honor. Give me one moment. Patty, are you signed in on this on here today?
I am.
Did you have some agreement with these guys?
Is this for Unit 199? I apologize.
It is indeed.
Yes, this is one that there was a numbers mistake on my part with their water read for April. An extra number was added. We have in turn asked to go ahead and dismiss. They only owe for May, which they were waiting for me to be able to get all these fees off. So,
okay. Do you want to dismiss or do you want to? I mean, I guess.
Oh.
What do you want to do? You want to adjourn it or you want to dismiss it? Or?
No, let's go ahead and dismiss. They should never been filed on. I do apologize, you guys.
Okay, got it. Cool.
All right.
Thank you.
Cases dismissed. That's without prejudice.
Oh, Patty, I'm sorry. I did see your email now on that one. We'll dismiss it.
Scio Farms versus Antoine Bailey. Antoine Bailey, not present. You may proceed.
Your Honor, Mr. Bailey actually made a payment in full this morning through the online portal, but we need to make sure that it clears. So if we could adjourn this one a week.
May 22nd, 2026, 12 noon. Scio Farms versus Rosalind Banks.
He's here.
Banks?
Good morning, Your Honor.
Good morning, Miss Banks. How are you?
I'm blessed, highly favored, and I live in Scio Farms.
All right. Okay. What is the claim in this case?
With costs, Your Honor, $776.39.
Okay. And Miss Banks, how are you intending on getting that paid?
Well, Your Honor, I received 4 notices. And on the very first one mailed to me, it has a different name on my petition, demand for possession. It has Anton Bailey and all other occupants with my name. The second one also has my name and Anton Bailey and all other occupants. I have 2 documents from the court, from the management with our names.
Okay, hold on, Miss Banks. The documents that you are holding up, what are they entitled? What's at the top?
At the top, it has the demand for possession. Is that what you're saying?
Yeah, is that what it's called?
Yeah, we have non-payment of rent.
Okay, hold on a second.
And it's for Anton Bailey. It's attached to my name. And we have the same docket number.
Are you lot 114?
I am.
Okay, the document I have, which is the demand for possession for non-payment of rent, has just your name and all other occupants. So I don't know.
Your Honor, just to clarify, Ms. Banks, is the demand in your name and there are other documents attached to it in Mr. Bailey's name? Is that what you're saying?
That is correct.
Okay, the other documents that are attached to it, what are those documents?
One is, well, I was reading what it is for Anton, and then I was had a sheriff to present the second document. A sheriff presented with Anton's name on it.
Do we have Antoine Bailey? Did I already do it?
You did Anton's already.
Can you give me
His
that
number was the
file?
one just before, Your Honor, 0714. It's the immediate preceding case.
Anton
Yes.
is at lot 715.
Oh, is it this one? It is. Thank you.
And he owed a lot more money than me.
Okay, all right. Is the number that you have owing 1993.73? Is that what yours shows?
The amount owing, yes.
Okay. And your name, okay, so that document that you're looking at, what's that entitled at the top?
Okay, there's two, and both say demand for possession. And it does list just the amount that's due, previous balance, total amount.
Yeah, do you see a complaint? Or
from Scio Farms,
Look the
landlord.
pages forward, Miss Banks. There looks to be additional pages that have been flipped backwards. What are those documents?
Those are in my name. They're in my name.
okay, so somewhere likely here or
I'm wondering,
someplace,
Your Honor.
you have, huh?
I was just wondering if
Someone-
maybe some extra copies got attached
That's
to her
right.
paperwork.
Okay, so let's do it this way, Ms. Banks. I'm going to end up adjourning it out anyway. Okay, so we'll get all of that straight. But there's 776.39 owing.
It does not say that amount, Your Honor.
Pardon?
It does not say that amount.
I know, but on the complaint that I have in front of me, okay, just so that we're clear, on the complaint that I have in front of me regarding yours, there was $564.82 plus cost.
Okay.
Okay, that was owing. So they've added the cost in, and right now your balance is at $776.39.
Oh, Your Honor, I have lived
Yep.
at Scio Farms for 26 years. I've
Yes, ma'am.
never been late in paying my rent or paying the water sewer bill. And that is what this complaint stems from. A break, supposedly.
Go ahead.
And I addressed it to the manager that I didn't feel that, well, first of all, I never received the bill, Your Honor. I never received this bill for the water bill of $686. As I stated, I've been there for 26 years. I've received a bill for those 26 years. If it didn't, it was because it was late. This is the first time in those 26 years I did not receive a water and sewer bill. I asked the complex to check it out to make sure there was nothing wrong with the meter. I was told just pay the bill, make arrangements. Since then, I've done everything, Judge, that I needed to do. It's not a lack of that I cannot pay my rent. I pay my bills. But I have had a lengthy conversation.
So, ma'am, let me ask you this. Are you saying you don't owe it? You don't know if you owe it, or you owe it? What are you trying to tell me?
I owe it. I do. I investigated by having plumbers come out and go underneath my unit to see where the water leak was coming from. Was it the fault of the meter, or was it actually a broken pipes? I had a company to come out, and it was a broken pipe.
Okay.
I'm not saying I won't pay the bill. Never said that.
Okay. All right. So what are you telling me right now? What do you want to do?
After 26 years of living there, never being late, I have printouts to show all that. And what I'm saying.
No, ma'am, Miss Banks, Miss
Okay.
Banks.
I'm getting.
Just listen.
Okay.
None of this is saying that you're a bad person at all or that you don't pay your bills. Okay. That is not the point here.
Okay.
What I'm just trying to do when plaintiff comes with a claim, trying to figure out how it can be paid and trying to make sure that people as best we can maintain their housing. So I'm just trying to figure out, you say that you owe it. How are you intending on taking care of it? None of this is a reflection on you as a bad person or somebody that's trying to abscond. Don't take it that way, because that's not what it is about.
I have had work done as far as trees being discarded because the complex would not. I paid over $700 and some, Judge, and I had asked the manager if we could come to some agreement and was told no. I have receipts, and that's what I wanted to do, was to use the monies, my own. The park is responsible for the trees, and that's what I wanted. Let's talk about making arrangements with the payments that I made on removal of those trees. Never, I was told, doesn't matter. So I wanted to come to some conclusion as to the monies I spent on those trees and this money for a broken water pipe.
All right. Here's what I'm going to do. I'm going to adjourn you out to May 22nd, 2026 at 12 noon. That's an in-person hearing. You'll need to come down to the courthouse. In the interim, you can call the plaintiff's attorney's office, see if there's something that can be worked out. If not, then you'll come down here, and at some point, I'll try to figure out how we're going to do this. All right, Ms. Banks?
That's fine with me, Judge, Your Honor. May the
All right.
22nd. Did you give a time?
At 12 noon.
12 noon.
And Your Honor, if Ms. Banks is not intending to call me to discuss the matter, which I'm open absolutely to having a conversation with her, I would request that she provide whatever documentation she has regarding this alleged tree removal, so that we were prepared to address that as well if this matter is going to go to a hearing on the 22nd.
Okay, you got that, Ms. Banks?
I have all of it.
Okay, but you need to provide it to the other side.
And Your Honor, I'm going to put my email address in the chat if it's easier for Ms. Banks to email it to me, or she can drop off copies to Patty in the office and Patty will get them to me.
I can drop them off in the office.
Thank you, Ms. Banks.
Okay, very good. Thank you. We'll see you next week.
Thank you, Judge.
Thank you. Sile Farms versus Jonathan Barrera. Barrera, they are not checked in. You may proceed.
Thank you, Your Honor. There's rent to retain of $6,059.02, costs of $192 for a total due of $6,251.02. And we'd ask for a default possession only judgment with a writ to issue after 10 days.
Judgment to the plaintiff, that's by default for possession, redemption amount, any amount requested, writ to issue at 10 days. Sile Farms versus Adam Bryant.
He's on sheet.
Mr. Bryant? You need to unmute, sir. I see you there.
There we go. Yes, sir, I'm here.
There you are. Okay. This one also has a note of a Friends Indeed referral. So is that correct, sir?
Yes.
Have you contacted Friends Indeed?
Yes.
All right.
Hi, my name is Shira. I'm a case manager with Faith in Action, and I'm representing my client, Adam Bryant. Faith in Action has agreed to pay.
Well, okay, hold on.
Sorry,
Who are you?
My name is Shira. I work with a nonprofit organization called Faith in Action here in Chelsea, and organization.
Yeah, I know. Okay, ma'am, I have to make sure we get you on the record. I'm not trying to interrupt you. I just got to make sure we have. And did you get her name? Shira. Got it. Okay.
Sorry.
All right. It's okay. Go ahead. What were you trying to tell me?
So I am a case manager with Faith in Action, and Faith in Action has agreed to pay the amount on his, 1,015 on his original document to avoid the eviction process. But to my understanding, there was they charged an extra fees and late fees and all of that.
Okay, hold on. Let's do this. What's plaintiff's claim at this point?
With costs, Your Honor, $2,385.75. Looks like the 1,015 is coming from the demand for possession. Your Honor, that's what's indicated on the original demand, as well as what's on the complaint from April.
Okay, so here's what happened. The 1015 was the amount of rent owing as of April. So now what's been included, there are going to be some late fees, but there are also going to be court costs and then May rent. So that's the distinction between the two numbers. You guys got that?
Yeah, I got that. I mean, is there any way to maybe figure out a payment plan? I have also.
Hold on, Mr. Bryan. Let me ask you this. So Faith in Action is paying the 1,015, right?
Correct.
Okay. Now my notes indicate you have a referral to Friends Indeed.
Yes.
Have they given you an answer at all regarding any payment or anything?
No, they had reached out to me yesterday, roughly about 1:30, and they needed documentation on like my income and those types of things. And I've sent those things over and explained to them that I had court this morning at 10 a.m. and I have not heard anything back from them. Faith in Action.
Okay,
also,
Mr. Bryan.
Yes, sir.
Mr. Bryan. Okay, just hold on a minute. Okay. Yes. All right, slow down. Nothing's going to happen to you.
Okay.
All right. I realize you and your worker were talking fast to me, trying to, nothing's going to happen. All right. Okay. I'm trying to get information.
Okay.
And then what's going to happen, Mr. Bryan, is I'm going to set a new hearing. I'm going to try to give, as in terms of time and everything, we need to try to get an answer from Friends Indeed.
Okay.
To see what it is. The very fact that they reached out to you but didn't get back to you, you're not going to be penalized by that. Okay? You got the information over to them. They've got to process it and then get the information either to the landlord or to the court or to you.
Okay.
Preferably all three. And then we can see where we are and then maybe head forth with a payment plan.
Okay.
That sound good?
Perfect.
All right. Does that relax you a little bit?
I'm still in a panic. I'm sorry.
Okay. All right. Well, okay. I got you.
It does make me feel good.
I tried.
It does make me feel good to hear that from you, but there's still a sense of panic.
Okay. We'll figure it out. Let's get the 1,015 in. We'll figure out what your balance is, and I'm going to set it for next week. Hopefully we'll hear Friends Indeed.
Okay.
And then we'll figure out where we can go from there. How's that?
Now, the 1,015, I dropped that off on Wednesday. They've already accredited my account. They had also...
Hold on. That was the 1,015 from Faith in Action got dropped off?
Yes, it's already been dropped off. It's already been... as far as my...
Hold on. Just, do you have that, Ms. Dornbush?
Let me check, Your Honor. There's been a massive amount of payments made in the last, I would say, I don't know, 18 hours or so by tenants at SIO. Patty sent me a slew of updates, so let me just make sure that I know about that one.
Patty's on.
Yes. Yeah, it was there. It's there.
Yep. So
okay, so it's been paid, but the number you gave me didn't include it.
That is correct, Your Honor. And so with taking into account that payment, it brings him down to $1,370.75.
Well, there was also a credit to my account because they had been billing me for a
month-to-month fees. I see that as well, sir.
Credited that.
Yep,
So
so
I-
1290.75 is the amount then, Your
Right.
Honor.
There you go. That's correct.
All right. Okay, we know where we are.
Yes.
Okay? We'll wait to hear from Friends Indeed.
Okay.
I'm going to adjourn it to next week, May 22nd, 2026 at noon. That's an in-person hearing. Okay?
Now that's
All right.
in Saline?
No, that's in Pittsfield Township by the Sheriff's Department off of Washtenaw.
I'm not sure. Yeah, I'm not sure. I know where that's at, but I'll figure it out.
Okay. All right. That's an in-person hearing. Come down and then we'll figure out where we go from there. Okay.
Great. Thank you so much.
That's fair enough.
I believe so.
All right, Mr. Bryant, I'm gonna give you an order.
Yes, sir.
Okay.
Yes, sir.
I want you to take a deep breath. I want you to relax over the weekend. Nothing's going to happen. Don't get all worked up about it, because you come in here and get all worked up, then I get worked up and bad things happen. All right.
We don't want that, sir. We don't want that.
Okay.
Thank you so
all right,
much.
Mr. Bryant, you have a great weekend.
Thank
and
you so
also
much.
to your worker, thank you for your help on this.
Thank you. You have a great weekend as well.
All right.
Bye-bye.
Scio Farms versus Paula Clark and Anthony Clark.
We're here.
Oh,
Good morning.
there we are. Good morning. Okay, what is plaintiff's claim?
With costs, Your Honor, $3,566.99.
Okay. Mr. Clark, how are you guys going to get this paid?
So, Judge Simpson, I don't disagree that I owe rent monies, but I filed bankruptcy in October 13th, and I contacted my bankruptcy attorney, and he told me that the monies that I owed prior to bankruptcy, that I should not owe those. But Miss Rachel, I don't want to butcher her last name. I'm gonna call her Miss Rachel.
Okay.
She sent a message to Mr. Dodd, who was my bankruptcy attorney, that they don't feel that I should be credited those monies because my husband is not a lease holder. My son and I are the leaseholders, but my husband is listed as an occupant on the lease. So I just wanted to find out from the courts, do I get a credit for those monies or do I pay? I have no problem paying. I just need to know.
And Your Honor, if I just may respond, there was a bankruptcy, there was some email correspondence. Under the bankruptcy, Your Honor, there was a lease assumption that would potentially negate any discharge of amounts owed. But additionally, Your Honor, the bankruptcy was filed by Miss Paula Clark and her husband. The lease is with Miss Paula Clark and her son, Anthony. And so to the extent that there would have been amounts that would be discharged to Miss Paula Clark, they still remain due as to Mr. Anthony Clark as the other leaseholder.
That
in
makes
short,
sense.
that's why there is no adjustment to the ledger.
Okay, that actually makes sense, Miss Clark. Miss Clark, you there?
Yes, I'm here. I'm here.
Okay, that makes sense. So maybe I'm going to put it a different way. Let's say that you and your husband, for whatever reason, may not owe it. You're still, the lease, the household is still going to owe it because your son's debt, which is joint and several to that, wasn't discharged. That makes sense to you?
No, but
that's why they're not giving the credit.
Okay.
That unit is still going to owe the money. It may just be in your son's name, but they may be the same result. All right.
Okay, so we did apply for assistance through DHS. The case is pending, just waiting for the decision on the courts.
Okay, so you applied for an SCR.
Yes.
All right. Did you apply for any other type of assistance?
No, sir.
Okay. So just to kind of put it all in context for you, how many people are in your household?
My son, me, my husband, our daughter, and his two sons.
So is that 5 or 6? That's 6.
6.
You know, that When I asked you if it was 5 or 6, that worried me that you had to look up and think about it, Ms. Clark, but that's all right. Okay. All right. So that you know, an SER, they typically, if you get it, they don't pay everything. So the most you get would be about 1,040 from that SER.
Okay.
Okay. All right. So there's a form that's in your packet called a rental assistance form. You'll need to fill that out and make sure that the tracking number that for your SER is on there, and get that to the court by next Wednesday. Okay?
Okay.
All right. And what I'm going to do is I'm going to adjourn your case out to May 22nd, 2026 at 12 noon. That's an in-person hearing, so we'll need to see you down at the courthouse, okay?
Okay. I mean, I do have 2,000.
Okay, that was my next question. My next question is, what can you're just trying to get ahead of me, Miss Clark. That's okay. How much can you pay between now and then?
I have 2,000. I just have to go to the bank and get a cashier's check.
All right.
And I can drop it off.
What I'll indicate is you'll pay that by Tuesday, the 19th. Okay?
Okay.
And then what we'll do is hopefully maybe we'll have an answer from the SER, maybe not, but then we'll see you down here next week and we'll figure out how we're going to handle the rest. How's that sound?
That's fine. I'm sure I can come up with it.
Okay. All right. All right, Miss Clark.
So what, next Friday at what time?
Well, at 12 noon.
In person.
In person. I look forward to meeting you.
No problem. Thank you, Judge Simpson.
All right. Thank you. You have a great weekend.
You have a blessed day.
Yes, ma'am. Scio Farms versus Melanie Clemens.
Oh.
Oh, there she is. All right, Miss Clemens, can you hear me?
Hello. Yep. Good to see you.
Okay.
Maybe.
See you. All right. All right. What is plaintiff's claim in this case?
With us, Your Honor, excuse me, $2,154.19.
All right. Ms. Clemens, how are you intending on getting this paid?
I have a check here from Selection for $981.73.
I'm getting an echo from you. Go ahead.
Can you hear me? I have a check 981.23.
Hang on. Shut down our video real quick and let's see if I get a better bandwidth. All right, Ms. Clemens, we turned off your video. Go ahead. What were you saying?
I have a check for $981.23 from Faith in Action. I can repay the remaining balance on the 23rd.
Okay. Give me the numbers on that check again.
981.23.
981.23. And so you're going to get that to the landlord by when?
Today.
All right, good enough. Get that to them. And then you're going to have the other amount on the 23rd, you think?
Yes. Actually, I will probably have it on the 22nd, but I don't know what time it'll post, but I can pay it on the portal on the 22nd, really.
Okay, so here's what I'm going to do.
Okay.
Is I'm going to adjourn it to the 22nd. That's what I can do. 2026 at 12 noon. Try to get that payment in. That's an in-person hearing, but try to get that payment in. If you can get it in before noon, that would be great.
Alrighty.
Okay?
Okay. Thank you.
All right. That's an in-person hearing. All right, Ms. Clemens, you take care. Have a good weekend.
Thanks, you too. Bye-bye.
Bye-bye. Scio Farms versus John Prode and Adriana Williams. Ms. Williams?
Yes, I'm here.
All right. I'm going to need you trying to put on your cam. There you are. Okay. What is plaintiff's claim?
With costs, Your Honor, actually, the total due, it looks like Mr. Crode and Ms. Williams just made substantial payments on the account. The remaining balance is $206 even.
Okay. All right, Ms. Crode. When are you going to pay this? No, I'm kidding. All right. Ms. Crode, when do you think you can get that clear?
I'll have it done by next Friday. I get paid on Friday, so I'll have that cleared up.
Okay.
And Your Honor, just to clarify, I lied a little bit, not intentionally, but it's 206.96, not 206 even. Can't forget the 96 cents.
Okay, so it's about 207. Is that going to cause you'll still have that?
Yeah, I can have it.
All right. Okay. So here's what I'm going to do. I'll adjourn it out to the 22nd, 2026 at 12 noon. That's an in-person hearing. However, Ms. Williams, I don't need to see you that day. If you get it paid and everything's all set, you're good. You don't need to come down unless you just want to see me.
Okay, sounds good.
All right.
Thank you so much.
Thank you. You have a great weekend.
You too. Thank you.
Sile Farms versus Lauren Eccles. Oh, where is she? There you are, Miss Eccles. Hello.
Hello.
All right. What is the claim?
With costs, Your Honor, $2,400.68.
2-4. Okay, 68. All right, Ms. Eccles. How are we going to get this paid?
I'm going to take a money order today for $500. I'm going to take another $500.
Hold on. You broke up there for a moment. I got money order for
$500 today,
okay.
and then another $500 on the 22nd.
Okay, you said another 500 by when?
The 22nd.
Whoa. Did she say 22nd? All right. Let somebody hear it now. All right. So that'd be 1,000. And then how are you going to get the rest of it paid? Do you know?
The rest can be paid by the 29th.
Okay. Glad you're catching.
I think she said the 29th, Your Honor, but I.
Well, we thought the 28th.
Oh.
You heard 29? You heard 28. All right. It'll be somewhere around then. All right. Okay. Here's what I'll do. I'm going to adjourn this out to the 22nd, 2026 at 12 noon. Okay. And so get those payments in. I'm going to suggest maybe that you contact Ms. Dornbush, see if you guys can work something out. But that's an in-person hearing on that date, so we'll need to see you down at the courthouse, okay?
Okay.
All right. Thank you.
Thank you.
Sile Farms versus Arkeem Kirk and LaFlora Jackson. Kirk, Jackson, they're not here. You may proceed.
Thank you, Your Honor. There is rent to retain of $1,064.26. Costs are $233 for a total of $1,297.26. We'd ask for a default possession-only judgment with a writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ to issue in 10 days. Sile Farms versus Kyle Crow.
Kyle is not here.
Kyle's not here, but it's like I have. Oh, no, there's Kyle.
Yes.
How's it? Tyler?
There's two cases, Your Honor. One for
okay,
Kyle, one for
okay.
Tyler.
I gotcha. All right. So Kyle's here. What is the claim on this case?
Your Honor, Mr. Kroll just made an $1,100 payment. It brought his balance down to $1,263.77.
All right. And Mr. Carl Crow, when are you going to get that paid, sir?
I should be able to have that paid here in about 2 weeks, but the paperwork that I have here says $1,075 or $74,045.
Right.
So
and that's so
May's rent.
Hold on a second. That's going to be through April and also does not include court costs.
Okay.
You follow that?
Yes.
All right. So why don't we do this? You need another 2 weeks. You need another check, basically, right? Is that what's happening?
Yes.
All right. So here's what I'm going to do. I'm going to adjourn this out to the 22nd, 2026 at 12 noon. What I'm going to suggest you do is contact the plaintiff's counsel's office, contact Ms. Dornbush, see what you guys can work out, either in a conditional dismissal or consent judgment, get you the time so that you can get this paid. Okay.
Okay. Thank you.
All right. Thank you. Court calls case People versus Tyler Crawl. Well, hello, Tyler. Oh, you're muted. He's working on it. Can you get yourself unmuted, Tyler? No? Okay. You got somebody there that can help you? Well, that was the camera. No, I don't. I think he's still there. Well, let me pass that one briefly. He's going to get somebody to help him, I'm sure. Saddle Farms versus Shane Meyer and Jordan Marshall.
Jordan's here, Your Honor. Looks like.
Yeah, I do. I do see it.
Your Honor.
All right, there you are. Thank you. All right. And what's owing on this one?
With cost, Your Honor, $2,404.46.
All right. Marshall, how are you intending on getting that paid?
I believe that's not noted as I did make a payment of $500. I do plan on discussing payment with my roommate who is not here at the moment.
Okay.
We've
So
just
you
been
paid,
having
hang on.
Yes, sir.
You paid $500. When did you do that?
Earlier this week, I believe Wednesday.
Patty, are you seeing a $500 payment? I don't know if I missed that update from you. Our ledger does not reflect a $500 payment, though.
It's loading. Hang on. Yes, I do apologize. On the 13th, he did pay $500. Total
Got
owing
it.
is $1914.46.
$1914.46. Okay. All right. And then you're not sure how you're going to get this all paid off at this point because you got to talk to somebody else, right?
Yep, not at the moment, Your Honor. We've been going through a rough patch, but I plan to get it all figured out.
All right. Here's what I'm going to do. All right. Well, two things. I'm going to adjourn you out to the 22nd, 2026 at 12 noon. Okay.
Mm-hmm. Yes, sir.
And then, is there any further amount you can get paid next week on this?
I get paid personally on the 22nd. I don't know how much I get paid, but I'll be putting my paycheck towards that as well.
All right.
And like I said, with my roommate, I will be discussing with him what he can pay as well.
All right. Very good. Okay. So I'll just indicate that you're going to pay something by the 22nd. We're not sure what it is because you don't know what your check is, right?
Yes, sir.
So we'll do that. This is an in-person hearing, so I'll need you to come down to the courthouse. In the interim, you feel free to contact Ms. Dornbush and see if you can work something out regarding the payment of all of this, particularly after you talk to your roommate and what they're going to contribute. Okay?
Yes, sir. Yes, sir. Thank you,
All right.
sir.
Thank you. We'll see you next week.
Yes, sir.
Court calls the case of Scioto Farms versus Sabina Newsom. Sabina Newsom. All right. Don't have it. You may proceed.
Your Honor, actually, there was a payment made today via the portal, so if we could adjourn this for a week to see if it clears.
All right. May 22nd, 2026, 12 noon. Scioto Farms versus Amanda Ridley. I'm sorry. Amanda Ridley. Oh, there she is. Okay. Can you unmute? There you go. Miss Ridley, can you hear me?
I can hear you.
Okay, there we go. I couldn't hear you for a moment. All right. How much is owing?
With costs, Your Honor, looks like Ms. Ridley just made a $600 payment. So we're looking at $931.31.
$931.31. All right. So Ms. Ridley,
Yeah.
how are you going to get the rest of that paid?
I get paid in 2 weeks and I will have it all paid in full by the 26th.
Okay, let's do this. I'm going to set this out 1 week to the 22nd, 2026 at 12 noon. That's an in-person hearing. What I'm going to suggest you do is contact Ms. Dornbush, see if you can work something out to kind of get yourself through that date, okay? That you can get paid.
Yeah.
Fair enough?
Fair enough. Thank you.
All right, thank you. Have a good day.
You too.
Scioto Farms versus Shannon Rousseau. Shannon Rousseau, not present. You may proceed.
Your Honor, if we could adjourn this one for a week as well. There's been a payment, but we need to verify it's cleared.
Got it. May 22nd, 2026, 12 noon. Scioto Farmers versus Derek Wanson. Yeah. And Elizabeth Wanson. Neither party's here. You may proceed.
Thank you, Your Honor. There is rent to retain of $1,116.21, cost of $233 for a total due of $1,349.21. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff, that is by default for possession. Redemption amount is in the amount requested. Writ to issue in 10 days. Scioto Farms versus Rachel Young, Ross Fortner, and Denise Fortner.
Your Honor, in this case, there was a payment, but it was via certified funds, and so we'd like to dismiss this matter.
Dismiss? All right. Case is dismissed. That's without prejudice. And let's see, Tyler Kroll. See if he worked out his. Oh, he did. I think he did. Oh, now. Oh, there it goes.
Hey.
We got you. All right. I had faith you'd work it out. All right.
Yeah, I had help.
Okay, that's good. All right. What is the claim in this case?
With costs, Your Honor, $4,413.01.
All right. Mr. Kroll, how are you going to get that paid?
So I have, I basically got to wait for another check.
Say that again?
I got to wait 2 weeks. I got to wait for another check.
And in 2 weeks, you think you'll be able to do what?
I have $1,600 now I can pay, and in 2 weeks I'll be able to pay the rest.
All right. So you got $1,600 that you can pay. Can you get that to the landlord by Monday?
I can do it today. Yes.
All right. Today. All right. Even better. All right. Get that over to them today. That's obviously going to lower your balance. I can adjourn this out 1 week to the 22nd, 2026 at noon. That's an in-person hearing. In the interim, if you're looking at working out, do you think on the 26th you're going to be able to pay the whole thing off?
I can look into some things. I should be able to.
Okay.
I can ask for some help. Yeah.
Okay. So let's do this. I'll adjourn it out to that date, pay the 1,600, and then contact Ms. Dornbush at the attorney's office and
Okay.
see if you guys can work out an agreement to get this paid. All right?
Yes, sir. Yes, sir. Absolutely. I appreciate it.
Not a problem. And we'll see you next week. That's an in-person hearing, so you got to come down to the courthouse.
Yes, sir. I appreciate it.
All right. All right. Thank you, Mr. Kroll.
Thank you. Have a good one.
You do the same. And I think that's it.
That is
That's all
it, Your Honor. Although there was a dismissal, and I don't know if Your Honor was going to call it for Scio Farms versus Robert English. I was chatting with him and I let him know the case was dismissed. He indicated he still wished to speak with Your Honor. I had assumed you were calling, you were going to read off the dismissals as you normally do, but this may have been one that was submitted early enough that it was already entered.
Yeah, I think it was submitted early enough. It came off the docket.
Understood, Your Honor. Mr. English, my apologies for the confusion. The judge actually is not reading that one off. And since there's no case scheduled for today, I don't know that there's going to be an opportunity for you to speak with the judge. But if you have any questions or concerns, you can certainly reach out to my office and see if we can resolve it.
He left.
He's still here, Judge. He's just muted.
All right. Well, let's see. I got a few minutes
I've got
here.
the
Let's
case
see.
number if you need it, Your Honor.
Yeah, if you would.
Yep, it's 264C 0725 LT.
0725 LD. All right. Mr. English? You'll need to unmute.
I'm on.
All right.
Sorry about that.
Oh, no, not a problem. All right. Your case, I had already taken it off the docket, but you're here. You wanted, Ms. Dornbush indicated you wanted to say something to me?
Yeah, because I'm just not understanding how I owe that money when no one told me when I went in there to pay it, and I paid them. So how do I owe them money that I paid already when no one explained to me that it was a court cost or anything? I also went in there and signed a new lease paper the same day I paid it on the 17th. And until I had them corrected, they had me on a month-to-month lease when I had to show them the paperwork that I wasn't. But my thing is that you took my payment on the 17th with no one explaining to me why I was signing these papers that I owe more or anything. And
okay, hold on. Owed more than what, Mr. English?
Then my lot rent was because of court costs and fines. They never told me that when I went in there to pay.
All right, your lease, well, first thing is, in any case that's filed, they're gonna be entitled to their court cost, okay? That's gonna happen. Your late fees should be really spelled out in any leasing agreement or by management as to when you would catch a late fee. So they don't need to really tell you that. If your case had proceeded through, I would have told you, quite frankly, that you owed the court cost.
All right.
Okay. I hope that answers your question.
No problem.
All right. Okay. Thank you.
Yeah.
All right. That's it. All right. Thank you for that one, Ms. Dornbush. All right.
All right.
It's okay. No,
I always leave it up to a tenant if they want to stay. I never tell them they have to go. Just,
No, I got it.
Normally
Some people just want to talk to me. All right.
All right. We'll see you this afternoon, Your Honor. Thank you.
Yes, ma'am. Thank you. Thank you, Patty. All right.
No problem.
Thank you, friend of the court. Do appreciate you being here. Court stands in recess.
Anytime, Judge.
All righty. Sure.
April. Ironically, it's what this attorney asked me to check into. And law enforcement was actively working on it, and I received it, made copies. I've hand-delivered that to both counsel. You set the co-defendant's case for August 17th for trial. I would ask that we keep these matters together.
August 17th.
Yes, sir.
Yeah, I just did that a little while ago.
Yes, sir.
Anything else?
Dr. He may have some announcements, yes.
So, yeah, the last court setting, I believe the only outstanding evidence I was requesting at that time, or at least I was aware of, was the 2 phone dumps. I believe the alleged co-defendant and my client's phones were both taken by police officers at the time of arrest. I've been given a flash drive and told it's a phone dump. I don't know which.
When did you get that?
Just now, I was sitting at the council table. As far as that, I intend on filing a motion for return property since the state has fulfilled its desire to download and copy the phones so my client can get his phone back. That is not filed at this time, but I will be filing that shortly now that the state has done what they need with the evidence. As far as going to trial, the last court setting, we did assert our request for trial, speed trial, so that we go forward. I don't believe the state can prove this case beyond reasonable doubt. My client is claiming innocence.
Okay, so August 17th, is that what you're saying? Set for trial, August 17th?
Can we do sooner? Can we do sooner than that? Maybe end of July?
You only try one at a time, and everybody knows I've just finished my 610th felony jury trial.
Wow.
Which, according to the internet, no one's ever done that.
Yeah.
So we're fighting fires here. 22nd largest county with the 16th highest crime. And then in this court, a lot of people ask for trials, which is a constitutional right, and I honor that. But I can only try one at a time, and apparently no one has ever done that many.
Absolutely.
So we're booked up as much as we can be. We just finished a trial yesterday, another 610. So we'll get to this one, and we're all booked up until then.
Should contain both those.
I'm sorry?
It should contain both those.
Anyway, that's what we're going to do is we'll set it for them. Yes, sir. And what we'll do is also, so we know, we'll prioritize it as a first setting, as a primary setting for everybody, because generally there's like 20 cases on the docket, on a trial docket every Monday, and that's just the way it is here.
For this one, Judge, we will need to make arrangements for a Mandarin interpreter.
Okay, who's going to do that?
I do not know.
You'll need to work together to see if y'all can agree to somebody, and because I don't know if there's one in Beaumont, but we may have to go to Houston to get it.
I think we did discuss this at the
level. Well, let's don't wait until that day to get one. Let's get somebody who y'all can agree on, what's capable and lawfully fits the requirements, so that we don't have to scramble around, because that could take a while. And we got 3 months here.
How would the court like to do? Because I know, we're going to get a translator all the way down here, and I don't want the court to have to pay for a translator to come all the way down here to sit here with a 20 case docket and not go.
That happens sometimes.
That's what the court would like to do.
But I want to prioritize this if it's specially said. But I wish I had $1 every time specially set cases didn't go. For whatever reason. It's not because I didn't specially set them and everybody agreed to do it. Things happen. And in 3 months, things can happen, but you're going to get a trial here. And there'll be a trial, unless I'm ill, there will be a trial on something that day. And hopefully I'm ready, willing and able to do it.
Absolutely.
But let's dot all the I's, and one of those is make sure that a capable, qualified, agreed upon translator is here, ready, willing, and able to go. How long do you think this case would take, Mr. Ham, to present?
Yes, sir.
How long would it take to present in your witnesses?
I have not analyzed that at all, Judge. Honestly, I'm sorry. I have not figured out.
Because I don't have a grip on it at all. I got to rely on the lawyers.
It's not going to take longer than the week the court would provide, Judge. I can assure you of that.
Anyway, that's what we can do. But we've already got fires
Absolutely.
that bonfire's going, that we will continue to deal with. I just wish there was a way to try more than one case at a time, but
absolutely,
if I can figure it out, I'll do it. But my just like I tell people, welcome to the criminal district court of Jefferson County, and nobody's tried more that I'm aware of. And I think there's an article in the internet on it.
I'm sure
somebody's researched it and they found nobody's ever done such a thing. So we are pioneers. Every case we try is a new record. And that's all I can do. I can promise you. And people get there. Everybody wants a trial. I understand it. But I'm the last person people can complain about, because I know there are courts that don't try hardly anything.
Yeah.
You know,
I'd say the only judge that could probably give you a run for your money would be Judge Andrea Bell. And probably a few
she's
Harris County.
Oh, yeah.
She has two
but I'm
trial
sure
rounds.
there are others, but nobody's reported. I had the same bailiffs from when I began, and they said that when we started, they said, "Oh, you're trying a lot of cases, man, and we're going to keep count on it." So it's this my same bailiff, and one of them is the same. So he's the official keeper of the amount of cases, and yeah, we just finished 16 yesterday.
And then one more thing, can my client be read his offer on the record, just so it's on the record that I have a translator?
Well, you can put it into the record. Yeah, that's not an unusual event. And then you want him to understand, make an expression he understands, and he's making a voluntary choice to pass on that offer and go to trial.
Yes.
Yeah, well, that's done all the time.
Okay.
Raise your right hand, sir. Do you solemnly swear or affirm that the testimony that you were about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. John, thank you.
Have I made you an offer on this case? Because I don't recall doing it.
You mentioned jail time at the last setting, but I don't remember the time that you provided.
Y'all want to take a moment to discuss that? Okay. What do we have left? Is it Mr. Bordash that's still left? That's all we have?
Yes, sir.
Okay, well, let's finish this matter, so we can just devote the rest of the time. Yes. I'm sorry. But
I did have an offer. I apologize. I did have an offer. Are you ready, Judge?
Mm-hmm.
The state's offer on this case to both co-defendants is a cap of 5 years.
does he know what that means? You can talk to him about what a cap means, because that's as you know, it's a variety of options that the court would have, which would include probation.
Yeah. So a cap would be, in other words, going to the judge with the state's request, whatever the penalty imposed would be, 5 years.
No more than, I'm sorry, no more than 5 years. That would be the most severe. But there are two other options as well that are probation.
I can let you explain it if you'd rather.
There are three options that a cap. When it's cap, it means whatever sentence shall not exceed the most severe option, and that is, in this case, this was was it a third degree felony?
Yes, sir.
Okay. The punishment range for a third degree felony is no less than 2 nor more than 10 years confinement in prison. And also, a fine up to $10,000 can also be assessed. A cap of 5 years in the agreement means whatever sentence, even though the punishment range by law is up to 10 years, then with this agreement, the defendant cannot be sentenced to more than 5 years. That would be the highest. That would work. There are two other options available. Forms of probation, which are not confinement, not imprisonment. One form is what we call regular probation, where someone is found guilty, sentenced, in this case, to no less than 2 nor more than 5 years confinement in prison with a cap of 5. And that confinement would be suspended, and I could place you on probation, and I could place you on probation for up to 10 years in length. There would be terms and conditions of probation, which are normal and customary in all cases. But in this case, it looks like restitution would be an issue. Is there a loss here at all?
20,000.
Yeah. One of the conditions of probation is if restitution is actually proven, then I would order the person responsible or persons responsible on probation to pay back the loss to the victim. If you failed on probation, then your probation could be revoked. If you failed to perform the conditions of probation, it could be revoked, and then you could be sentenced by the court to up to 5 years in prison if that happened. So probation is a second chance. You don't go to prison as long as you follow the terms. At the end of the time, if you did well, the case is terminated. But you have been found guilty, and that could affect future. You've been found guilty of a felony in that case, and that could affect job opportunities, maybe. Citizenship. Maybe, I don't know. Now, there's a third option. It's a form of probation. It's called deferred or unadjudicated probation. And in that case, if that were done, I would make a finding that there is enough evidence to find you guilty. But I would defer or postpone any finding of guilt as long as you followed the terms and conditions of probation. If you did that, at the end of your probation, the case would be dismissed. And you would not be found guilty. If you failed on deferred probation, your probation could be revoked. Then I could find you guilty and you could be sentenced up to the cap, in this case, up to 5 years in prison. Now, that third option is the kind of probation that we use most regularly on probation because people have a second chance. But they have to perform probation properly, or else their probation could be revoked. So deferred or unadjudicated probation, if you do well, the case is dismissed, you move on, and you're not found guilty. On regular probation, you are found guilty. You were sentenced, placed on probation. If you do well, at the end of your probation, if you do well, the case is terminated, but you are still found guilty. You just don't go to prison. That's important. And then again, the final option is prison. No less than 2 nor more than 5 years confinement in prison. Okay. So those are the 3 options. Yeah, nobody wants prison, of course. Yeah. But that's why when people generally, very, very, very few people ever say, I want to go to prison. But some people are before me and they're not confident that they can successfully complete probation because they know they have issues and problems. But out of the people who are placed on probation in my court, 93% are successful probationers. 93. National average is 75, I think.
That's very high.
93 is very high because we have a good probation office that work with the defendants because we don't want to see failure. And we're very proud of that. That's good for the probationer, good for everybody. The important issue here, I think, in this case is restitution. And that's generally the most important issue in all theft cases. We're going to make sure that the person who's victimized gets their money back, whatever they lost. That's important. That's all, and that's what's right and fair. So those are your 3 options, and your attorney seems like a smart man, and he'll help you understand the good and the bad on each of those, and what decision will help you in giving you information so you can make the right choice. Now, we're not going to do that today.
Absolutely.
So what do you want to do today?
I just wanted my client to be made aware on the record what his current offer is, and a record present that he does have a translator present, ensuring that that has been conveyed. I've seen some appellate cases where that can come up. I want to make sure we're getting ahead of anything like that. And that my client wants to proceed to trial at this time. I'm unaware of this.
We're going to set this for trial. If you want to decide to plead guilty and make a deal, maybe on those probation offers or whatever, let us know, because we have a lot of cases on trial. We try more than anybody here, but if it can be disposed of without a trial, let's do that. And if he wants to get on probation, then let us know so that we can move it off the trial docket. The important thing is the quicker you get on probation, if that's what you're going to do, the faster you're on probation, the faster it ends. Delays in this court don't help anybody. It's not good for anybody. So make a decision as soon as possible. Well, until then, we'll put it on the trial docket. Anything else?
Nothing further from the defense.
Thank you.
Thank you.
Please get a resetting from this lady. Mr. Bordat? John Bordat?
Absolutely. I think I got a sign too. Yeah. Thank you, sir.
John, you're representing Mr. Bordat?
Yes.
Okay. 23 CR 1439 is now called the State of Texas versus John Walter Bordash Jr. Present with Mr. John West, his attorney, the state's attorney. What are we doing today? I know it was reset.
Judge, the restitution has been paid.
The restitution has been paid.
We sent the doctor off to be treated for incompetency. In September, we got
of last year.
Yes, we got in September of 2025, we received a report that said that the doctor was not going to regain competency within the statutory limits, but they recommended outpatient treatment. That was back in September. He's been incarcerated since then, so I don't know what to do now because the only other options are.
How about outpatient treatment to help him?
Well, we got to get him out of jail. That's what you
said. That's going to have to be done with probably a civil commitment to outpatient
what does
treatment.
It take to get him out of jail?
And we only
because he's done his obligations, right?
Yes, sir.
He's met his obligations.
Well, we've got his obligation. He's been incompetent, but we've got restitution paid, like you said. I just had the hearing Monday on that.
Well,
and we can only keep him on the outpatient commitment for about another 130 or 40 days because he's got 426 days credit in jail plus what he spent at the hospital for about 90 days. And then now we can only keep him for the 2 years on the state jail. Then we have to cut him loose.
And I have requested, Your Honor,
stand by. Hold on. The sentence that we assessed him originally.
There's no sentence. He's not been sentenced to anything. This has just been jail and hospital time. He's got.
Okay. Incompetency is not a affirmative defense.
Right.
Okay. So what does the state want to do? Y'all are the prosecutors. Y'all brought this up. What, under these circumstances now that we face today, what do you think is in well, it's what y'all's oath is, and you do a great job. What's in the best interest of justice for all concerned, most importantly, the defendant?
Well, here's the complainant is here on the case, and they're afraid for him to come back to the neighborhood because of the issues that have been caused over the years with him, and so he still needs help. I just don't know what we can do as far as helping him other than a civil commitment to outpatient
well,
treatment.
It's something. It would be like everybody else, I would think.
Yes, sir.
If he's no longer subject to the criminal system for punishment, we just can't keep a person in Twilight Zone. And if Mr. Bordash commits a crime, he knows what's going to happen. He'll be back up in here, and it could take years.
Yep.
But but that's presuming he's going to go and commit a crime. I think he doesn't want to face more confinement.
No.
I think freedom is a wonderful thing he understands and appreciates. I want him to get treated, but also we just don't put people in the twilight zone of confinement.
That's the problem, Your Honor, is that if he's incompetent, we can't plea it. We can't resolve it that way because he's got enough credit to govern time serves. I mean, we know that he's in that range. I've requested the state to consider dismissing it since the restitution has been paid. And as you know, in a lot of cases, these type of cases, that's usually the way the deal's worked out from the beginning. Is if restitution is paid or something like this, we could get its dismissal.
I understand.
If not for his actions and incompetency, but that would have been done.
But the future safety of the community is also the reason criminal law came into.
So that's what I'm saying. And normally, if we have a situation where this person is competent, we have no issues there. That's the way it can be worked out. But we've had issues where his incompetency and his ideology has caused problems. So
we'll just let the rule of law work itself. I think it's time he's released, but he is subject to criminal sanctions if he commits a violation. And if he does, criminal law is built, subsequent problems result in higher forms of probation and more severe responses from law enforcement and the courts.
Are we going to do it in the form of a civil commitment, or are we going to do it in the form of a PR bond with an order as conditions of bond to be under care for a while until we make sure he's okay? Because if we're going to do a civil commitment,
what I want to do is I want the parties to inform me of what are the options that the court has.
Yes, sir. Well, if we do a civil commitment, the one thing that concerns me is the only report we have is from September of last year. And that's 7 or 8 months ago. And so I don't know that we can do a commitment based upon those at this current time. So the only other option would be to place him on a bond to order him to do that for a while until we see that everything's okay once he gets out. And then if everything's stable and he's okay, then maybe we can dismiss it and get rid of it and go on about our business. I just want to make sure that not only does are they safe, but also that Mr. Bordage's is
Bordage, isn't it, sir?
Bordage. I'm sorry, sir, Dr. Bordage. If he's okay, he's not going to be.
I think there's a way of appeasing everyone here. I'm going to release them.
Yes,
but there will be, he will continue on a bond. This case will continue to stay open, and we'll review it from time to time just to make sure he's doing fine and there aren't any problems. Also, the purported victims here, I want their safety to be ensured.
Absolutely. One
of the conditions of bond and release is to have no contact with is it Mr. Payton?
Yes, sir.
Yes.
Nor anyone on your behalf contact him. Do you understand, sir?
Yes.
That will, okay. And you can follow that. And if I find out that that has been encroached or you fail, it would be very quick. A warrant would be issued, bring you back, and your bond would be revoked. Then we're back in a situation that no one, especially you, wants. Just follow that rule and don't commit any crimes. Those are your two basic. One other thing, though, John, with Dr. Bordak, one other thing is, what is it to help him continue any kind of treatment that helps him to fulfill these obligations successfully?
Your Honor, he has a list of doctors. We gave this, mentioned this last time. He has a whole list of doctors that he sees that he wants to get back to seeing again. But I don't know how.
What about that?
Oh, I've been wanting to jump at it since October 2nd.
Okay, what does that do for you? Hold on.
Screwed up right now.
What does that do? Because the courts used to more conventional forms of treatment.
Yeah.
What is it that you find from this treatment that helps you to follow all the rules and live a happy, safe, lawful life? What is it that holistic method does?
Oh, I need to go back to my primary care physician, because while I've been in the county facility.
Who is that?
That is Patricia Salvato.
Salvato.
Okay.
Indiana, Houston.
In Houston, Texas.
Okay. Is it the court is going to order as a condition of bond that you do that? All right.
And I need to go see my neuropsychologist. I've done that
That's my right.
since 2011.
That's going to be another condition of your bond, that you fulfill that. That'll be an obligation I'm going to help you with.
And I need to go back to seeing Dr. Kulkarni.
And what does he do?
That's a psychologist, psychiatrist, right?
Yes.
All right, that's good too.
And then also
where's he located?
He's in Beaumont. Okay.
He's in Beaumont.
Other ones have been in
I'm not familiar with.
And then I need to see a neurologist.
Mary Foe.
Houston Methodist.
All right, get those.
I can give those to Ellie. And
Ellie and
I have those right here.
Thank you.
You will be ordered as a condition of bond to seek the treatment quickly, timely, and fulfill their requirements of you in whatever the doctors prescribe, treat, and authorize to help you move forward, so that we don't have to come back and deal with any problems, which will again begin with a condition: don't commit a crime.
Yes.
And that's a condition of bond, and then those will be added, those treatment methods that have been put into the record. I just need their names, locations, so that it's on the record. We will review this case every 6 months just to see how you're doing, to make sure that there's not a problem, or that if there's something the court can help you with, get things done. Let me know if you're having obstacles getting all of that accomplished.
Well, I did report obstacles, and that is Mr. Payton himself. He goes behind your back despite what you tell him, and he continues his harassment.
All right. Well,
you're about to get out. Don't say anything.
All right. I'm not aware, except for you, your statements. The state of Texas, though, they're the people that would do the investigation. If there is a problem, I'm not aware of it. It hasn't gotten to me.
Here's the issue: is Mr. Payton is the president of the Homeowners Association, and Mr. Bordage, or Dr. Bordage, has there's been some non-compliance with the Homeowners Association, but they're just going to have to learn how to deal with that.
Until this case is over, I think it should be just
the Homeowners Association. Everybody involved in that needs to deal with it selflessly and work things out. I'd rather a law enforcement agency or the courts not get involved in any homeowner association unless there's criminal activity. Those are things everybody has a unique thought process, and on issues there are differences of opinion. Somehow through the ages we have worked things out, sometimes peaceably, sometimes not, but we are capable, intelligent people are capable of dealing with each other in a responsible fashion. And I'm going to presume that that can be done. If it's not, then if there's a problem, there's a breach of the peace, a crime committed, then we'll deal with that on a bond issue.
Okay.
But it's give and take. It's not going to be 100% your way. You know that. And it's not going to be 100% everybody. Everybody has to sacrifice a little bit. Everybody's got to work together. We all don't, none of us get 100% of what we want. Just doesn't work that way. That's the sacrifice we make with 7 billion people on the planet. Let's work it out. And responsible people, professional people, intelligent people are more than capable of doing that. And there isn't any reason that this court needs to come in and referee a homeowners association There are always conflicts and differences of opinion. Work them out responsibly. If you're a responsible person, that can be done. And I don't see any reason why the people who are mentioned here can't responsibly work this out. But also come in with an attitude of trying to work it out, not being defensive or combative. Friendly.
That has
As
been a
best you
problem.
can, let's be friendly.
That has been a problem since he doesn't hold annual meetings like he's required to.
I'm not gonna make a ruling on
I'm
that.
concerned about the HOA yard man.
And there are methods of dealing with HOA issues, and it's not for this criminal district court.
Well, I'm hoping he's
Work it
not
out.
a family member
Look,
because that's nepotism.
People,
And it can be a problem.
issues are brought up. Responsible people always seem responsibly to deal with them, and compromises need to be reached in many cases. Just act civil, mature, responsible, and also remember that your actions, even on the homeowner associations, if people see them and they make decisions on what kind of person and personality people have. You want to enjoy a good reputation, and you want to be part of a successful venture like a homeowner association. You want to move forward, not drag it down, right? Because when you move forward, everybody moves together forward. Come on. But it's not always 100% on the terms, and issues need to be addressed, but do it civilly, responsibly, as though you were setting an example for children who are watching, who would be influenced by how you do things. Let's act responsibly an adult life. We're talking about professional people here. Come on. Every 6 months we'll deal with it and see how we're doing. Okay. Anything else? All right. Good luck. And let's do our best to get along. Anything else?
Well,
we are recess. Thank you.
So when it meets on the wall, what do I do?
Thank you all for being here. Let's go on the record. Good morning, Mr. Yoder. Can you hear me? I can hear you just fine, Judge. All right, thank you. This is Judge Middleton. I'm here by special assignment on a circuit court matter for the County of St. Joseph. I was familiar with this case earlier when it was a district court matter. The title of the case is People versus Timothy William Lewis Yoder. Mr. Yoder is present by Zoom with us from the St. Joseph County Jail. Also present with him is his counsel, Casey Strong. Also present from Three Rivers by Zoom is Assistant Prosecutor Angelique Canfield. We also got a reporter here, and we've got some of the staff from the circuit court also present by Zoom. This matter is scheduled for a jury trial for the 26th, I believe, of February. Excuse me, February 26th of May. And the parties have been working on this for some time, and I believe to have worked out a resolution in this matter. As I've indicated, the original charge was bound over from the district court. The file number of the circuit court matter is 2025-25935FH. Mr. Yoder, the original charge alleged that on or about September 21st of 2022, that you did enter a home without permission at 2806 South Centerville Road in Sturgis with the intent to commit an assault. that is a felony. It's punishable by up to 20 years imprisonment and a fine of up to $5,000. Am I in the right case?
Oh, Your Honor, that's not I apologize. This is Timothy William Lewis Yoder.
Yes,
That's not correct.
Got the wrong file, so let me get the right file. There were some similar acts motions, so I copied all the other stuff. And let me get in the right file. Excuse me. What are we doing? I've got a 225 file, but I don't think it's the right file. I'm just going to go in my file. This is the proper case. The district court file number was 251947FY. The circuit court case number is 2525935FH. Mr. Yoder, the allegations are substantially different than what I was first advising you. This alleges assault with intent to commit great bodily harm, less than murder, with strangulation or suffocation against Angela Marie Yoder. That is alleged to have occurred in Lockport Township on September 21st of 2025. That is a felony. It's punishable by up to 10 years imprisonment and a fine of up to $5,000. Second count is domestic violence, third offense. It's alleged that you had at least 2 previous domestic violence convictions, which makes that charge a felony, punishable by up to 5 years imprisonment and a fine of up to $5,000. You're also charged as being a 4th habitual offender, which would make the assault with great bodily harm punishable by up to life, and also a 5-year felony as a 4th offender is also punishable by up to life imprisonment. It also affects the sentencing guidelines in the matter. Mr. Yoder, before we go further, I'm going to ask you if you'd please raise your right hand. You swear or affirm any testimony or information you provide in this matter will be true to the best of your knowledge and belief.
Yes, Judge.
All right. As I indicated, this matter is set for jury trial, and I've been assigned to a couple of days worth of trials. This matter is charged, as I indicated, with assault, great bodily harm as a 4th habitual offender. My understanding is the parties have worked out a plea agreement. Ms. Canfield, what is the plea agreement in this matter?
Your Honor, it's my understanding that the defendant will be entering a plea of no contest to the initial count 1, assault by strangulation, as a 3rd habitual offender. At the time of sentencing, the people would move to dismiss count 2 and the remainder of the habitual notice. And I believe Ms. Strong will state the reason for the no contest plea is a higher level of intoxication at the time of the commission of the offense.
What is the maximum punishment for a assault with intent to commit great bodily harm as a 3rd felony offender?
I'm looking at the statute right now, Your Honor.
And I'll defer to you, Ms. Canfield, stating the cap recommendation. That is part of the plea agreement as well.
That is correct, Your Honor. We did have an agreement that the people would recommend a cap on prison time at 72 months, given our understanding of the calculation of the guidelines.
One habitual makes it half again as much, which would make it a 15-year offense. Two
I think the
habituals.
third doubles it. It doubles it, Your Honor.
All right, so it would make it punishable by up to 20 years imprisonment as a maximum sentence. All right, Mr. Yoder, there's a lot to unpack here. We also discussed a no contest plea. Is it your intention here to plead no contest to these charges according to the plea agreement that was placed here on the record?
Yes, Your Honor.
Anybody threaten you to get you to do this?
No, sir.
Push you anything other than what was said here?
No, sir.
Do you understand that by pleading no contest to this charge, you'll be giving up your right to have a trial and there will be no trial? Do you understand that?
I do, Your Honor.
Now, I do these rights often in district court. They're a little bit more expansive in the circuit court. Do you understand that by pleading no contest to the charge, you will give up your right to have a trial in front of a judge or jury?
I do.
At that hearing, you'd have a right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You'd have a right to have any of the witnesses against you subpoenaed to come to court so they could be cross-examined. You would also have the right to compel witnesses by the power of subpoena to come in and testify on your behalf. You would also have a right to testify on your own behalf, but you do not have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have a right to have this matter proved beyond a reasonable doubt. And certainly you have a right to be represented by an attorney. Ms. Strong has been appointed to represent you. You could also hire an attorney if you wish. When you enter a plea in a felony case, you have no right to appeal as of right. You would have to ask for leave to appeal this matter to the Court of Appeals. And you understand that by entering this plea, you waive all those rights.
I do, Judge.
All right, Ms. Strong has provided me with the advice of rights, and I greatly appreciate that, Ms. Strong. She met with you in advance at the jail, and you've signed this acknowledgement of the advice of rights and this initial document for the Michigan Department of Corrections. Is that correct?
Yes, sir.
Now, the reason for no contest plea, as I understand it, is because you were intoxicated at the time this incident occurred. That is a legitimate reason for a no contest plea. By pleading no contest, you don't admit what happened, but you don't exactly deny it either. I would get my factual basis from the affidavit that accompanied the original complaint. You understand?
Yes, sir.
Actually, Your Honor, if I may, Ms. Strong and myself have agreed that the court may also look at the preliminary examination transcript and the original police report, which have been shared both with Ms. Strong and with the court. And I believe Your Honor oversaw the preliminary examination in this matter as well.
Yeah. Is that agreeable with you, Ms. Strong?
Yes, Your Honor, I have no objection to that. I've discussed it with my client. He also has no objection to that. There is no one. That's why we couldn't.
I'm gonna have to get into the circuit court version of this file because I don't have the police report in my file.
Your Honor, Ms. Wilkins emailed it to 3B District Court so that you would have access to that.
All right, that's probably very good, except nobody gave it to me. So 3B criminal to, you sent me those email messages late yesterday. And if there's an email at 3B criminal, would you please forward it to me? Lapita, I don't know if you can hear me. Anybody can hear me?
I can hear you, Judge. I just forwarded it.
Jen, would you go check on that, please?
Your Honor, I just sent you that email.
All right, very good. Let's see here. It takes a long time for that email to get from the jail to here. I do have familiarity with this matter because I did conduct a preliminary examination. While we're waiting for that, I did ask you if anybody had promised anything other than was on the record. If anybody threatened you, you indicated they had not. Is it your choice to enter this plea of no contest to this charge of assault, great bodily harm as a third felony offense?
Yes, Judge.
All right. Now, there's been discussion on the record regarding the sentence cap and the sentencing guidelines. The court makes no representation regarding what the sentencing guidelines in this matter will be. I wasn't able to calculate them because I didn't know what the plea agreement was until just a moment ago. All right, but the guidelines will be determined at the time of the sentence, and the prosecutor has agreed to cap it if the maximum of the guidelines is 72 months. Do you understand?
And Your Honor, just to rephrase, my understanding is that, and my client's understanding is that MDOC will run their guidelines, whatever their guidelines are. The agreement of the parties is that the prosecutor will cap it at 72 months.
Yes, as a recommendation, that's correct, Your Honor.
All right. That's a good way to pin it down.
Does that make sense to you? You understand that? Yeah. I just want to say it a different way.
I do appreciate we had a difficult time scheduling this. People are busy. They're in different courts. Judge Pattison was very busy in here. Angelique's in 3 hours. Casey was here, and then she has other obligations at Kalamazoo. We were able to accomplish this. All right, as I indicated, I did hear the preliminary examination in this matter on October 28th of 2025. Angela Yoder, excuse me, Angela Yoder did testify at that time.
Your Honor, just as a correction, Angela Yoder did not testify at the preliminary examination.
This is the one where we have the officer testify in lieu of the victim being. But I do recall that testimony. It was full of excited utterance and other evidence that supported the bind over, including photographs. But I'll refer to the police report. The report was prepared by Trooper Andrew Stahl, the Michigan State Police, indicated they were dispatched to the scene at Woodland Drive in Lockport Township on that date, which was Sunday, September 21st. They met with a complaining witness and she indicated that her husband, Timothy Yoder, had strangled her. They observed redness to the right side of her neck in the form of a handprint. Then they spoke with Timothy, who stated he did not choke her, but they further investigated this. Had to do with a dispute about a car, and there was photographic evidence of the injuries on the the complainant's neck. She had apparent redness in the form of a handprint on the right side of her neck. She had what it appeared to be webbing behind her right ear. Webbing is caused from injuries sustained by a person who has been choked or strangled. Ms. Canfield, is you satisfied with that factual basis?
Yes, Your Honor. I would add that I believe the police report indicates that Ms. Yoder's statement, in addition to just saying she'd been choked, did verify that that meant to her that her breath was cut off for a time period during which she thought she was becoming unconscious. And I do believe that those satisfy the factual basis as elucidated and the criminal jury instruction 17.35 as well.
All right, will you accept that, Ms. Strong?
Yes, Your Honor, I would accept that.
All right. She also does talk about the defendant intoxicated at the time this was going on. He indicated that drinking and quite a bit and refused to take a test. So I find sufficient evidence of intoxication for this no contest plea.
Thank you, Your Honor. I believe if we could also inquire as to his habitual offender status.
All right.
He's going to ask a question here.
Mr. Yoder, the complaint alleges that you had at least three previous convictions here in St. Joseph County. One is a conviction for, am I the wrong one? We'll start from the newest to the oldest. Convicted in St. Joseph County Circuit Court on May 24th of 2000 of the felony offense of possession of methamphetamine. Do you acknowledge that?
What year was that?
Would you repeat the year, Your Honor?
May 24th, 2019, 45th Circuit Court, possession of methamphetamine.
Yes, sir. Yes, Your Honor.
And September 12th of 2016, 45th Circuit Court, once again, possession of methamphetamine. Do you acknowledge that was a conviction and that was?
Yeah, yes, sir.
Are there any probation or parole consequences to this plea?
No, there are not.
All right. I think we've covered the fact that there will be no later claim of outside off the record promises or coercion. Once again, Mr. Yoder, was there anything that anybody said to you outside of the purview of this hearing which would have threatened you or induced you to enter this plea other than what was placed on the record here because of the plea agreement?
No.
All right. You seem very clear-headed here this morning. I find that this plea is voluntarily and knowingly made, and I will accept the plea to that charge of assault with intent to commit great bodily harm by strangulation as a no contest plea. The next thing we need to do is schedule the matter for sentencing. We had worked on that point, and the matter has been scheduled in front of me live here in this courtroom. I have a notice here. I got so many notices. I believe we picked June 19th. Let me look at that date.
That's correct, Judge.
That is correct, Your Honor.
June 19th at 11 a.m.
Thank you, Your Honor.
Mr. Yoder, I will be the judge handling the plea in this matter. Normally, I would ask if you would have any objection to it being assigned to another judge. We do have other judges that are fulfilling our circuit court obligations, but I'll handle this one. And this is an assaultive offense. I'm going to cancel the bond. There's no sense to leave it open. At the time of sentence, the domestic violence third offense charge and habitual will be dismissed. The habitual will also be dismissed. Probation department will prepare a pre-sentence report, which they will share with court and counsel, and will have an opportunity to review it prior to the sentencing on June 19th. At that point, we will be more specific with the sentencing guidelines in this matter. The court, as I indicated, has no position as to what the sentencing guidelines are. In the sentencing hearing, we will agree on what they are. The court will make a finding, and I will proceed according to the cap given by the prosecutor. All right, Mr. Yoder, do you have any questions?
No, I do for my attorney, but you can handle that.
All right, you can handle that separately. Ms. Camp, is there anything else you believe we should have placed on the record here?
No, I will just acknowledge that I'm not aware of any threats or inducements or promises to Mr. Yoder to enter this plea either, and that I do believe that the court complied with the statutory taking of the plea. Thank you.
I'm supposed to ask that.
And yes, Your Honor, I also do not believe that Mr. Yoder was under any threat, coercion, or inducement not placed on the record, and I do believe the court has complied with the court rule.
Thank you. I do have a little checklist here. All right, Mr. Yoder, the next hearing in this matter will be June 19th at 11 a.m. for the sentence. I'm going to ask everybody to stick with me for a minute. I'm going to stop the record and close out the live feed. I want to inquire about some other matters. So thank you all for making time for this to happen. We went into the lunch.
Right. Who that man? All right. Where are we on this case?
Balance of $3,950.
All right. So from last week, I had that you were going to. Sorry. That you were going to pay $1,000 that day. Did you pay that?
Yeah, I paid $1,400 all together today at 9 o'clock.
So you paid the $14,000.
No, I didn't have the $4,000 on the last Friday.
So you paid how much you say today?
$1,400.
Don't have any indication of that.
No, we got ledgers yesterday, Your Honor. So
All right. So if you did that, which you got about 2,500. It's still, how are you planning on paying all of that?
Well, I was gonna ask for payment plan, if so.
Are the clients working out payment plans, or how do you want me to do?
Your Honor, I'll reach out to my client and ask if they're willing to do a payment plan, with Ms. Allen. Ms. Allen, do you want to give me an email address or a phone number and show?
Okay.
You want me to adjourn it out 1 week?
Yes.
All right. Ma'am, I'm going to adjourn your case to May 22nd, 2026 at 1 PM. Again, another in-person appearance.
Okay.
And let's see, they'll reach out to you and see if we can get something worked out.
All right.
All right. Take care. Take care, little man. Said, I am not talking to you. Harbor Manor versus Salim. Said Al-Araja.
Al-Araj.
Say it again.
Al-Araj.
Al-Araj. Okay. All right. How are you today?
I'm good, sir.
Still needing in for plaintiff?
All right. Where are we on this case?
Your Honor, I have a balance including court costs of $2,023.
All right. All right. How are we going to get this taken care of, sir?
So, if I have a time to talk a little bit.
Okay.
Salim Al-Araj is deceased on November 29.
Okay.
And this is his death certificate.
Okay. I believe you.
And Hala Arosasi, I am the legal guardian for her. And this is the paperwork from the court.
From the probate court. The legal guardian for Hala
Arosasi.
Hala. Okay. All right.
So as soon as Salim deceased, we move Hala to her son home, and he was taking care of her because she has dementia.
Got it.
And she has SSI $994 monthly payment. We paid to Arbor Manor December and January. And we was in the middle of funeral and all that things for Salim Al-Araj and empty the apartment and clean it up. And we gave the apartment at the end of March to Arbor Manor.
Okay. So the apartment's cleaned out. You turned in the keys and everything to Arbor Manor. You have no knowledge of that.
I have no knowledge, but if I can see the guardian, do you mind? May I see the copy of the guardianship papers? We might be able to just put proofs on the record.
Okay.
Thank you so much. Okay.
So to your knowledge, there's nobody in the unit, correct?
No one in the unit.
And then I'm sorry, just to be sure, do you have like an ID or something?
It's in my car.
Okay. Okay.
Well, if you're
There's full guardianship.
right.
And so I think we can put proofs on the record.
Well, it seems to me you turned in the keys.
Yes, Your Honor.
So this is a possession only. So maybe what I'll do is I'll just adjourn it out a week.
Okay.
You don't have to come back. Let them check into everything that you're saying. And if that's the case, they're going to dismiss because they have the unit. Fair enough?
Fair enough. Thank you, Your Honor.
You're welcome. So I'll adjourn this to May 22nd, 2026 at 1 PM.
May 22nd.
Yes.
Okay.
And you, if everything checks out, you don't need to appear because they'll just dismiss the case. So what you may want to do is just call their office.
Okay.
And then you'll be all set.
Thank you, Your Honor.
All right. Thank you, sir. You have a great weekend.
Let's just look at it if you were going to put here.
Forrest Knoll. versus Ahmed Ajin.
Hi.
Hello, your name?
Ahmed Ajin.
All right.
Julian Ian for plaintiff.
All right. How much is owing on this?
You pull up the folder. I got them all out of order.
No, it's okay.
It was all in order, I promise, by my first step. Okay, I have a balance including court costs of $3,852. Mr. Ajin and I spoke earlier this week. He's planning to move out by the end of the month and is looking to resolve the balance with a payment plan. I reached out to my client and I just need to hear back from them as to whether they're going to be, they're going to accept that payment plan.
So since this isn't for that, I just find you're moving out at the end of the month. Is that it? So what I'll do is I'll find no tribal issue. I'll issue a judgment for possession. For that total amount of 3,852. But the writ will be extended to this way. You don't have to come back to May 30th. I'll just do it. It's a Saturday, but I'll just do May 30th. 2026. All right, sir. You understand that? So what I'm doing is I'm issuing a judgment. You'll have to the end of the month.
Okay.
If you don't pay the money, they'd get to remove you anyway from the premises, but you're going to leave.
Yeah.
And then you can work out a payment plan with them for the back balance.
Okay.
Fair enough. That way, unless you want to come back down here and see me. Well, don't be so fast to say no. I mean, but all right, fine. All right. All right. So that ought to work it out for you.
Okay.
All right. Take care. Forrest Knoll versus Arlene Bonner. Your name?
Arlene Bonner.
It's this one. That's which one?
Yeah, I was late writing that judgment for the previous.
Oh. I was wondering. I got it. What? No, I had everything organized. Bonner, they're just messing me up. All right. Where are we on this?
I have a balance including court costs of $1,630.
Okay, she did an intake on 5/12. Go ahead.
1422 now. 1422 now.
You made a payment.
I made a payment last week and I'm going to make a payment Monday because when I get off of work, they'll be closed today.
All right, so did you apply to SOS or Hawk, right?
Hawk and DHS.
Okay, so Hawk is reporting that your intake was on May 12th, right?
Yes, at 10 o'clock.
Received documents from you and are awaiting documents from the landlord for review. So
They sent the paper. The office sent the paper 2 days ago in my mailbox and said I owe $1,422 now.
Okay, gotcha. But
I don't know I honestly, I don't know your.
Because I gave them $1,400.
Hold on.
Okay.
The last payment that I have, just to make sure we're clear on the payments, was May 5th, $500.
No, I gave them a $1,400 check.
Okay, I see, $1,400.
That was the last one. Yeah.
Okay, it was broken out into 5522 on the letter for some reason. Since then, so after that point, there are late charges for May, and then the court costs are added on to that. for a total of the 1630.
Okay.
But we can.
But did they give any indication? They were waiting on landlord documents at Hawk to determine what they can help you with. Is that your understanding?
Yes.
Okay.
The caseworker. What's the case?
No, they don't list who the caseworker. Do you remember your caseworker?
I think her name was Alicia, but I can't remember her last name.
That makes sense. Okay. So let me do this then, ma'am. I'm going to adjourn you out a week. Okay. To the 22nd, 2026 at 1 p.m. And an in-person hearing. Let them get the documents over there, figure out if they're going to help you with anything. And if not, then we'll figure out where we go.
Can I still pay? Because I do have 900 today, like I said, to give to them on Monday, a money order.
Okay, you can. Okay, you can do that. Why don't you do this for me?
Okay.
This balance isn't going to go up anymore.
Okay.
Why don't you? Can I trust you to hold that, or you take it out and spend it?
Oh no, I'm not like
sure.
I'm positive.
Sure.
Positive.
Okay. Don't come back here talking about, well, I saw this purse or something I want.
Oh no,
I'm just kidding.
I'd rather have a roof over my head.
Yeah, I got you. I understand. So, and the reason I'm just hold on to the 900.
Okay.
Let them get the documents and let's see what they'll pay.
Okay.
Because if they won't pay the whole balance, but they'll pay part of it, we may be able to, or if they're going to pay the whole balance, we can get yourself ahead for June.
Okay.
How about that?
Perfect.
Okay. I think that'll work. And then that way things get less stressful.
Okay. Right.
Okay. We'll see you next week at 1.
Thank you.
You have a great weekend. Outside Lakes, why do you have that vest on?
Me?
Yeah.
Oh, I work with special need kids.
Oh, okay. Okay, so you work for the school. All right. Yes, ma'am. Who? Me and you? What do you mean?
On TikTok.
Oh, well, I don't control that. My things are just streamed and people come up and they put it on there and then they tell me I'm on, I don't know. Because I'm not on social media, so my kids tell me.
Oh.
Okay. Take care of yourself. I just wanted an orange vest. I want to wear one of those out here. Go outside Lake 1 and 2 versus, is it BK Diarrhea?
Bakai Diarra.
That's what I said. Why are you
No.
I'm kidding. All right. How you doing?
I'm doing good, Judge. How you doing?
Yeah, I'm doing okay. I messed it up the last time too. So, all right. Where are we on this case?
I have a balance of for costs of $4,345.16. But I believe Mr. Diarra
was he
following up with some with MAP and Friendly from last week and see if that could be fruitful.
All right. Where are you on this, sir?
So recently my vehicle has that's why I'm not there currently right now, but recently my vehicle has been impounded. So that situation has totally threw me off of what's currently going on right now. So I like, sat and contemplated. I do get out of my lease next month, June 15th. I was wondering if I can get until June 5th to, move everything out and just, start a payment plan because, just everything is just backed up without me having a vehicle.
All right. So you're thinking of just moving out. Can't get out before the end of the month?
Nah, because the vehicle, I don't have a vehicle currently with me to get everything out. So
so you need that next week.
Yeah.
What you're saying.
Yeah.
All right. Let's do this.
Did Mr. Diarra say June 5th or June?
You said June 5th.
June 5th, yeah, June 5th.
I think we can do that.
Okay. All right, we'll do it. Here's what I'll do. If I know tribal issue, I'm going to grant a judgment for possession. I'll extend the writ date to June 5th, 2026. All right?
Okay, Judge.
And then you'll be all set. All right?
Yeah,
Go
no
out,
problem.
get yourself settled. Take care of yourself, young man.
Thank you so much, Judge. I appreciate it. You
All
enjoy
right,
your day.
All right. Hamilton Crossing 1 versus Crystal Stanley. And John Stanley and Jordan Haley.
Oh. Jordan, that work.
Yeah. Your name?
Family.
All right. Well, what do we have as a balance on this?
Julian Engen for plaintiff, Your Honor. I have. I have a balance of the court costs of $1,074.
All right. All right. Oh, we're gonna get this paid.
Yeah.
Oh,
Oh, yeah. I talked to Miss Dorsey yesterday and she said I need a COD. And that I had to come to court, make sure it's paid by the 31st.
So you're planning on paying in full by the 31st?
Yes, yeah.
Okay. Your Honor, I'd happy to do a judgment release that is in full.
okay, I can do that.
It probably will be earlier than the 31st, but
Okay. So what counsel's indicating is that they have a judgment. I would just find that there's not a tribal issue for the court
okay.
case. I'd extend the writ date out or the order of eviction date from what would normally be the 25th to the 31st.
Okay.
You'll get it paid. If you get it paid, then dismiss the case.
That sounds great. And then
Fair enough?
fair enough.
All right.
So it's a.
Yeah, right, because that's a Monday.
Okay.
So I'll find no tribal issue. Grant a judgment for possession. First or thereafter, 2026. All right. And I'll sign the judge paid. They'll set it aside. Everything will be all set.
All good. Thank you
All
very
right.
much.
Thank you. You have a great day. Weekend. I'll pull that. That way you Hamilton. Hamilton Crossing 1 versus Tammy Evans. Oh, everybody waving at each other. Oh no, watch her. Hello,
Hello.
what's your name? Oh,
And
thanks. No.
it's on social media.
All right. All right. And let's see, where are we on this? You had indicated there were certain repair issues for you.
Yes, sir.
Did those get addressed at all, or where are we? So they didn't get addressed. Nobody came over, or what?
Hey,
Oh, okay.
That the bedroom window leaks and then, what's going on with the dishwasher? Is it just, it's not working or?
it's not working and it's full of water. And it's a smell come from it in the washing machine and the dryer. It's messed up.
Wait, I had
The washing machine
here before, it was the bedroom window. There was then the washer and dryer
and dishwasher.
and the dishwasher.
Yes, that's it.
And I think when we did that, because we were on Zoom at the time, that Mr. Fink was going to try, I think he was here,
Yes.
going to try to get somebody over there, but nobody's come over yet.
No, sir.
All right.
Your Honor, I just.
All right. What do you have as the,
Balance currently $927.
okay. So, so she's paid quite a bit. I mean, so I mean, she paid, because I had, that she was gonna pay 1,500 by Monday. That would have brought her into $2,000 range, but she's obviously made another other kind of pay.
Your Honor, the balance that I have is 927. It looks like there was on the 8th. I'm gonna have to, I don't have the ledger that we had that date, but I will follow up. Does the 927 sound right to you? Or does it sound lower than what you would?
I'm not sure.
Okay.
I just want to be able to pay what I owe.
Right.
Hang on. So here's what you told me. So last time we were here, the balance that was given, including court costs, was $3,687. She had indicated she was gonna pay 1,500 by Monday.
That is correct. And
I paid
Did you do
it.
that, ma'am?
Yes, sir.
Okay, she did that.
so I don't know what the discrepancy is, Your Honor, but obviously the balance that on this ledger on May 8th is different than what
Right.
we would have had last week. And so what
Gotcha.
I do is I don't know if this is it subsidized, the rent subsidized.
Okay, so that might have been it, like a payment came or something.
Yeah, that might
Okay, got it.
double check them.
Okay, so I'm gonna adjourn it out a week. I want the sheet. I want these repairs done. Because as I recall, she told me the last time, she's been living with these for a while now. She asked that they be done, and I'm not saying that they can fix them all right away, but somebody needs to get over there and check on them. And so I want that done before we come back next week. So I'm gonna adjourn you out. What? Yes, me. No, it's okay.
I can't come in person because I get off work at 1. I work 5 a.m. to 1. So I can't unless it's later.
Your Honor, do you want
So
to?
you don't want to see me?
I love to see you.
No, it's okay. It's okay. No, I'm not. You know, people are offending me all over the place today.
I don't want you to be offended.
All right. I know. All right. So you get off of work at 1.
5 to 1. I work 5 to 1.
Do you want to turn it out
2 weeks. Okay. I'll do this for you. Okay. 29,
Okay.
2026 at 2 p.m. Will that work better for you?
Sir,
All right.
date it.
See, I can be nice. All right.
Oh, nice.
You take care. You have a great weekend.
You.
All righty. Hamilton Crossing 2 versus Anthony Kaba. She's on the shoot. Grant application.
Brian Ingen for please?
That means. Hello.
Hello,
What's your name?
Fatimata Kaba.
Okay. I have a note from Hawk, and I don't know how to interpret it entirely. It says waiting for electronic signature for grant application from client.
Yeah, and then I sent that in yesterday. My caseworker, Alicia Sykes, I think. She's in the process of getting that check sent over to the office, I think.
To the complex? Okay. So you were at the end, your understanding is you were at the end of the process.
Yeah.
You needed to sign and then it was gonna
Yeah.
go. All right, what do you have as a current now? 2002. All right. So what I'm gonna do, ma'am, is I'm gonna adjourn you out to the 22nd, 2026 at 1 p.m.
Okay.
Okay? Hopefully they're gonna get over there. There might be a slight discrepancy of about $50 somehow or another, maybe, who knows? All right, but hopefully then everything will be paid and we all set.
Okay. Thank
Okay, thank you. New Park Ridge versus Sydney Dodd.
As this doc comes up, Your Honor, we spoke previously and she did different application.
Yes, and they Hello, what?
Hi, Sydney. That
Okay. I have a note here that Ms. Dodd has been approved for $1,652 in rental arrearage. She was approved on the 13th.
Oh.
What's your next 1652.
Your Honor, the balance that I have is 1654.
I think your math is off by $2. Okay. All right. So she was approved for that, but you guys don't have the check. So let me ask you this. If you had to come up with the $2,
Guess I'll pay it.
I should make her not pay it. So
I do got a question though.
that she would pay it.
I would. I got babies. I gotta keep my house. I said I got babies. I gotta keep my house.
I got you. When
So I'm not sure if you remember, but the last time that I was here, it was the furnace issue. You had stopped it and dismissed the case that I had before until that was fixed. They did have somebody come out. It was during the winter earlier this year.
Okay.
They did have somebody come out, but they weren't able to connect the air. They had to basically rig it kind of to just get the heat going for us. I'm back and do
now,
but they still haven't came. So I was trying to see if somebody could come out. I've emailed a couple times, but still nothing. And then also we have a bird now in the dryer vent that I had asked for them. Like they keep coming through the outside. I don't know. I just here and I ran outside. So I don't know. Yeah, so it's live bird. And so they just keep coming back and forth.
Going to invest?
Oh no, I don't do animals. But they keep
all animals or just birds?
I'm scared of birds. I don't know why.
Okay. Me too.
Okay.
All right. I just don't like them flapping around. I got you.
So
all right. So when are we gonna get that bird out?
They keep so that's the thing. They go out, but they come back in. So I had spoke to them about they were supposed to put a sheet up or something like that, but it still hasn't been done. So if
all right,
put one up for
so here's what I'm gonna do. Bird in the vent. I want somebody to check her air conditioning because if that blower doesn't work, she's not gonna get air.
Okay.
And then do something about that bird.
Please, bird.
So I'll adjourn it out to the 22nd, 2020. Well, if the check is on the way, let me go to the 29th. I'm going to go 2 weeks out. Let them try to get out there and get that all solved. And then that's at what? 2 p.m.
That's beautiful. Okay. What day is that?
That's the 29th.
What day is it?
Friday.
Friday. I might be in class because I'm in the nursing program, but we have clinicals and they switching our schedule, but I think we're switching to Fridays. So do I have to be in person?
You're supposed to be in person, but
I can talk to her. I'll ask my teacher first if I can step aside because it's right down the street.
So here's the issue. I don't want you missing class, but because the issue, I don't want you missing class to get down here. You think that if I gave you Zoom approval, you could appear via Zoom?
That's fine.
All right.
I asked her to first. I'm right. It's literally right here by St. Joe's. So I'm not far, but I just want to make sure that I'll be able to step out.
Okay. All right. So we'll work that out. Nothing. The worst thing that nothing's going to happen. I just want to make sure that these repairs are done and that they get the check over.
Thank you.
And we'll do that. Okay.
All right.
So when are you going to be a nurse?
February 27th. Yep. So next year, I'm almost there.
Next year?
Here.
How long you been doing?
This year, it's only a 12-month program through St. Joe's. This is the first one.
That St. Joe's?
Mm-hmm.
Okay.
I work there.
That part of that are they connected with the nursing program at Washington?
Not yet. So I'll be doing the bridge program there. So I'm doing the LPN program right now, but I'm going to bridge over to RN after I'm done in February.
Gotcha.
So that will be through.
Okay.
Yes.
Gotcha.
Yep.
Well, congratulations.
Thank you.
Yeah, that's fantastic.
Thank you. Then just
New Park Ridge versus Alana Armstead. I do.
Okay.
She on there?
Yep.
Planning.
Okay. So what do you have her owing?
$1,004. Letter of commitment.
Yes, that's what we have. And a letter came in, or a note came in indicating she's sick and contagious. She said she has paid the rent, which I'm assuming she means that, so.
How would you adjourn it?
Yeah. During this to 22nd, 2026, 1 p.m. All right. Strong Future Homes versus Jamila Williams. See, I knew that was her. Watch her closely. Hello, what's your name?
Jamila Williams.
And where are we on her case?
So I did speak with the attorney earlier in the week. We actually emailed back and forth to sign a consent form.
Yeah, Ms. Williams is looking to get funds released from her 401.
Okay.
So I just need the judgment in order to them.
Oh, gotcha. Because there was going to be the hardship.
Yeah.
And you need.
Yeah.
Just want to make sure that they understand what. Okay. We can do, so we could do a consent judgment that has a date, and so I think what day you have it all paid to the date. But give yourself enough time for it to
process and everything. So maybe 2 weeks. It shouldn't take that long. It's all about fact.
The problem is that I could adjourn it out 2 weeks. I don't have a problem with that. But if you get it in today, I'm looking at the way they've been running with other people, but I don't know, is about 10 days.
Yeah.
Before they're going to process it out to get to you.
Mm.
We're going to lose 2 days because of the weekend.
Right.
So what if we put June 1st and no writ without a hearing?
That'll work. Okay, what that would mean, ma'am, is that I'd be finding no tribal issue in this case. I would enter the judgment for possession. Okay, in the amount, what'd you say the amount was again?
1,804.
Okay. For that total amount, okay, we would set a order of eviction date, meaning if you don't get this paid by the 1st of June, then they could apply for an order of eviction.
Okay.
But we're going to add language in there that there's going to be no writ without a hearing. And what that means is they can't just do it, send it in, sign, and then next thing you know, you got a sheriff showing up. It has got to come back before me.
Okay.
Before that happens. That way, if there's a delay with your 401k or whatever, we'll all be back together to know. So it won't, nothing bad happen.
Okay.
Fair enough?
Yep. So I'll get that paperwork today.
Yes. What we're gonna do is do that. And then I'm gonna extend your writ to the June 1st, 2026. No writ without a hearing. And then I'll issue that. I'm gonna sign that judgment, ma'am. Okay.
Okay.
And then what I'm gonna need you to do so that you'll have it, so you can try to get it over to them, is you can go down to the clerk's office. They'll give you a copy.
Okay.
Okay. And then that way you'll be able to send that off to whoever you need to.
Sounds good.
Okay.
All right.
All right. You take care. Have a great weekend. The Haven versus Raymond Stewart III.
Jillian Egan for faith.
And Morgan, you're right. It's not here. Okay.
No, I'm Raymond Stewart.
All right. What do we have?
Balance including court costs of $4,620.82.
All right. How are we going to get this taken?
Yeah, I thought I was all good, and then the student loans processed before the rent payment. So done a DHS
application doing FASCO with them. I only get paid once a month, so I wouldn't even be able to pay again until 29th or whatever the last business day of the month is. So I was hoping we could do like a payment arrangement or something, but we're trying to figure this all out.
So let me get this. You're a student?
No, not anymore.
More? Okay, so what got paid? How'd you?
The student loan payment went through first before the rent payment, so my bank denied the rent payment.
Oh,
yeah. Student loan payment wasn't even supposed to be due that day. They just made an error. And of course, I can't get that back for 21 days.
okay. So your student loan payment got made. And so they didn't pay the rent. And so you say you don't get paid till the 29th. But are you going to be able to cover this balance on the 29th?
Majority of it. I'm hoping that FASCO at U of M can help me out, as well as DHS.
All right. So did you do a DHS?
Mm-hmm.
Did?
Yep. That was a couple days
ago,
Yeah, like
when you found out about everything else.
Yes. As soon as I started.
Okay. So just so you can put it in perspective, how many people are in your place? Two? Two. All right. So if DHS awards their maximum amount, you're only going to get about $520. That's all that they're going to have. Then you say you'll have your check by the 29th.
Yes.
And then you're looking for other.
Yep.
You know how much your check is, how much you're gonna check towards your rent?
$3,200.
3,200?
Yep. Okay. So you'll put 3,200 toward your check. Okay. So here's what I'm going to do, sir. But you don't have any funds till then.
No, I made a payment of $500 yesterday or the day before.
Okay. All right. Hold on. You don't have that because I don't.
I don't see it. Here. Wait. That's the right one?
I don't think you have it, only because I'm looking at last week's number and it went up by the.
I got the receipt in my book bag.
Yeah.
You're good.
Yeah. We just get our ledger for noon the day.
Oh,
so
I don't believe you, but she did. So
I got the receipt.
Yeah. All right.
No, we're not.
All right. Yeah. Go.
What do you think about adjourning it to the 29th? If Mr. Stewart can, it's going to be 2 p.m. So Mr. Stewart can make that payment like early in the morning.
Yeah. You can do it then? Yeah. All right.
And have, maybe at that point, we talk about maybe doing a judgment so that we can freeze the amount.
Got it. Okay. I don't have a problem with that. May 29th, 2026 at 2 p.m. All right. Make sure to get that payment in, then we can check it and do whatever.
All right. Thank you.
All right.
Thank you.
Everybody believes you'll do it. I'm skeptical, but all right. Court calls the case, The Haven versus Jeffrey Perry.
Billion Hagen for free.
How you doing? I'm doing well. Yourself?
Oh, great.
You're Mr. Perry?
Yes, I am.
All right. And where are we on his case?
The balance in pretty court costs is $4,260.52.
All right.
You have a note from my client concerning the repairs issue.
Okay.
So, they performed a mold test, and they didn't really find it much. So maintenance supervisor walked the apartment, did a kills treatment. Bathrooms. They also repaired the first floor holes, had both bathrooms painted. The toilet parts were replaced, and the lid switched to the water place. There is one toilet repair still pending. There was a part that needed to be ordered.
Got it.
That's the notes I have.
So they came in and did some stuff.
Some stuff, but the washer, it wasn't replaced. It still doesn't work. They took it apart and they never came back over with the part. They said they was going to come back over 2 days ago, but they never came.
Is that the switch that's missing, or You say they replaced the switch, which sounds like it wasn't operational. But then they would have put a switch in. It should have been operational, but you're saying it's not operational.
Yeah, they did. They say they don't have the part. So they said they would have.
That might be the part they're ordering then.
Okay.
Okay, got it. All right.
So for the bathrooms, it's still doing the same thing. It's causing, like when I first moved there back in December, later I let them know what was going on. They delayed the mold test for like 2 or 3 months. They didn't do it until I said
But they just did a mold test.
Yeah, they just did it. Yeah, but they just did it. Was this like 5 months later? But I requested back in December.
Okay, so what do you want me to do with that?
Yeah, I had a lot of damages since then because
What damages?
had to get hotel for some days, had to miss work some days. I was in the house getting really sick. They say it's not mold, it's something in there. And I still have it.
All right, so has any rent been paid?
Not since the end of March.
Okay, so why hasn't the rent been paid?
It initially because I had a lot of repairs and stuff that need to get done. I kept promising to come, haven't came, kept saying they're gonna come, didn't come. I didn't pay the rent, went on ahead and mold test. And then said they had a little.
You have the funds.
I have some of it now because I had to use.
How much do you have?
I have 2,000.
All right, but if you have 2,000, where's the other 2,200 going to come from?
See, when I applied for the SURF program with DHS.
How many people are in your unit?
2.
So the most they're going to pay is about $520.
Yes, and I'm asking the court to exercise the MCL 554139. The house is not in unlivable condition with the home being that way. Like right now, I'm sick and irritable.
All right, look, if that's fine. If that's no, I don't exercise that. You need to file a written answer. I'm going to order that written answer be due. You need to file a written answer by the 22nd. Alleging all of your complaints and the basis for which you're not paying rent. I'm also going to order the escrow to be placed within 7 days. Today's the 15th, so I'm going to order it as of, hey, what is monthly rent?
$1950.
I have 1780 is just rent, and then there's other monthly fees that are, but the rent.
The base rent is $1,780. And then, all right. I'm going to order escrow in the amount of the 17. That would normally be due on the 1st of the month for beginning in June. You're to place $1,890 or $890 into rent within the next 7 days. And then 1780 thereafter as we go forth. I'll let them. Hopefully that part will come in. I'll adjourn this out to May 29th, 2026. So your answer is due next week. I'll see you in 2 weeks at 2 p.m. And then you need to deposit the $890 and then the $1,780.